Good morning, everyone. I appreciate you all coming, and particularly shout out to my Morris Nichols colleagues who showed up today. It was very nice of you. Before we really kick off the program, I wanted to do some brief introductions and let each of the panelists say a little bit about their role in the Time Warner case from 1989, 1990. I actually see Rich Hines in the audience, too, who might have been involved somehow behind the scenes in no, that's right. You started the same year I did. That's right. I'm Bill Lafferty. I'm a partner of Morris Nichols. And as I told the panelists, I reminded them on one of our prep calls that I was not involved in this case. I actually had just graduated from law school and became a law clerk in the Court of Chancery. And I do remember when this case was decided, it had been argued right before I started my clerkship, and everyone was kind of on pins and needles waiting for this big opinion to come down from the Delaware Supreme Court, and ultimately did in early 1990. And Rich Hines, who I see out there, actually clerked for Chancellor Allen. That's why I remember it. But in any event, I wanted to briefly let everyone do a little introduction. To my immediate left, to my left, is Ken Forrest, who's a partner from Wachtell Lipton. To his left is Professor Larry Hammermesh, who at the time this case was decided was a partner of Morris Nichols. And then to Larry's left is Justice Randy Holland, now I guess retired Justice Randy Holland, who is now Wilson, Sonsini, Goodrich, and Rosati. And to his left is Louis Lazarus, a partner at Morris James. And last but not least is Dave McBride, a partner at Young Conaway. And I'll let each of you, if you want to go in order, or Dave, why don't we let you go first since I introduced you last, and just tell the audience a little bit about your involvement in the Time Warner case and who you represented, and maybe just how you got involved.
Well, we represented Paramount in the case, and I don't quite remember how my firm got involved, but we had previously been involved on the plaintiff's side in the Revlon case and had won that, so I think there was some hope that lightning would strike twice, although I don't think anybody thought it was. But and Bruce Stargett was the senior lawyer on the case for our firm. Bruce has passed away, and Josie Ingersoll is living the life in Sonoma, California. She was on the case, and an associate, then an associate in our firm, who I have a story to tell about, was Jan Jordan, who's now, of course, the present judge of the Superior Court.
I'm Louis Lazarus, as Bill Lafferty said. I'm at Morris James. I think I'm on the panel because they wanted the perspective of somebody who was in third grade at the time, and to see how this has stood the test of time afterwards. I was a very young attorney. We got into the case. You may recall that there was a TRO at first to enjoin the share exchange that was part of the original structure of the transaction. After that TRO was denied, our clients, who were substantial stockholders in Time, needed counsel, wanted to intervene. Dave McBride called Clark Collins, who was my partner, and said, we have a conflict. They were then representing Paramount, and we got involved on behalf of the intervener at that point. I'm sure others will talk about this. There's a phrase in here about how the Time deal was strapped to a rocket. I can tell you all of the lawyers were strapped to a rocket, because that was a very intense period of time, and maybe later we can comment about how, in an age when you did not have the internet, how that affected lawyers doing work in expedited cases.
I'm Randy Holland. I was one of the three justices that participated in deciding this case, and I got involved kind of by luck of the draw. At the time, the custom was to primarily decide cases in panels of three that were assigned somewhat at random, and so I was one of the three assigned to hear this case. And the other two justices were Justice Moore and Justice Horsey, who are no longer with us. But you recall this case was decided in 1989, and Justice Moore had done Revlon, Unical, and Aronson in 1985. and Justice Horsey had done Smith versus Van Gorkum in 1985. So this was the heyday of the takeover era. And one of the issues in this case, as we'll talk about later, was the interaction between Revlon and Unical.
Larry Hammermish here. I got involved in this case as Bill said, when I was at Morris Nichols, partner there, and I got involved in it because Gil Sparks was busy. I think he was working on a takeover of Dunkin' Donuts. So you all remember the Dunkin' Donuts takeover, right? No?
I do, Larry.
So
I
think
go
I
to
got
Dunkin' Donuts every morning. Does that mean I'm disqualified?
partial takeover, right? So that's how I got involved. I worked with Martin Tully and Tom Hunt, the late Tom Hunt, and they were more senior, but somehow I was the one who got dispatched to handle the less important arguments, and was involved mostly in working on the briefs in the case. But we represented Time Inc. and its directors.
And I'm Ken Forrest, and I'm of counsel now with Wachtell Lipton. Everything I say today is cautioned by the fact that the 1980s is a blur. This was, as Justice Holland said, this was a hotbed of M&A litigation activity, and I was right in the middle of it, including Revlon, including Time Warner and others. It was very exciting times, and this was just another major case for a great client, Warner Communications, which was a fantastic media company, owned Warner Brothers Film Studios, the second largest record company in the world. And this was an extremely high-profile matter, and I think for those of you who don't have a lot of familiarity with it, I think you'll find it to be a very interesting story that we're going to tell today. Great memories, but please recall this was a long time ago.
Yeah, speaking of that, I did also mention I wanted to give a shout out to the associates who helped put together some slides, and I will tell you that they were not born when this case was decided back in 1990. So we're gonna play a little video clip, a little multimedia entertainment here before we really kick off the panel, and we're gonna go to that clip now.
60% of the new company. In addition, by agreeing to walk down the aisle with Warner, many believed Time was making itself ripe for a raid. They were right. On June 6th, Paramount Communications, the producer of such films as Indiana Jones and Top Gun, entered the bidding. The blockbuster $175 a share offer for Time. Wall Street immediately applauded the bid, sending Time stock up 44 points on the news to $170 a share. At Time headquarters, however, management was not nearly as enthusiastic. Time saw the Paramount bid as a call to arms, and the battle was on. For nearly 10 days, Time's bankers, lawyers, and directors met around the clock to plot their strategy. Using code names from Warner's hit movie Batman, they devised a defense. Rather than merge with Warner, Time, codenamed Robin, would buy Warner, codenamed Batman. In a debt-laden transaction, the two hoped would make it too tricky for Joker Paramount to acquire. But before Time could cry wholly hostile takeover, Paramount took the case to the Delaware courts, where all three companies are incorporated. So far, however, the courts have tipped towards Time. Less than 2 weeks ago, a lower court refused to block the Time-Warner deal, saying management was acting in the long-term interests of the company. If Paramount loses in the Supreme Court as well, most Wall Street analysts say it will be nearly impossible for Paramount to take over Time. But it's also unlikely any courtroom decision will be the final chapter in this takeover tale. Paramount has not ruled out coming back with a bid for both Time and Warner, or in a different twist, Paramount itself could become a takeover target. This is Terry Keenan, CNN, reporting live at the Delaware Supreme Court.
Terry, it may interest our viewers to know that this case is being tried in a Delaware courtroom. When you think of media giants like these companies involved, you think more in terms of New York or L.A. typically. Why Delaware?
That's right, Marianne. Well, all three companies, Time, Warner, and Paramount, are incorporated here, as are about half the Fortune 500 companies. It's no coincidence. Corporations like Delaware, they like their tax laws. They also like the courts, which are generally very fast and efficient. In fact, some people say that you can get a decision here as quick as you can in traffic court.
Terry Keenan, thanks for that live update. And of course, we'll be getting further reports as the battles continue between Time Warner and Paramount. We're joined with financial news now by Stuart Varney, who's sitting in New York. Stuart.
Thank you, Marianne. Delaware's Supreme Court hears a case today that will have a wide impact on takeovers. Paramount Communications wants to block Time Inc.'s merger with Warner Communications. Paramount wants shareholders to decide the issue. Time and Warner want that decision in management's hands. A lot of money is at stake, and so too is future takeover strategy. Standing by in Wilmington to cover the Delaware Supreme Court's hearings is CNN's Terry Keenan. Terry, who will we be hearing from today?
Well, Stuart, starting off, we'll hear from the attorneys for Paramount, as well as several large-time shareholders, including billionaire Robert Bass. After that, it will be Time's turn, and the oral arguments for the entire hearing will go about 2 hours.
Okay, Terry Keenan at the courthouse there. We'll be hearing more from Terry later today. Now, in our New York studios, we're joined by someone who has been following this case very closely and who can help us, hopefully, guide us through the legal procedures. John Coffey is professor of law at Columbia Law School. Professor Coffey, welcome to the program.
Thank you, Stuart.
What's so special about Delaware? Why is this decision of national importance being taken in that state?
Well, Delaware is the jurisdiction of incorporation for about half the New York Stock Exchange companies and a similar percentage of the Fortune 500. It's the jurisdiction of choice of the most mobile, actively traded large public corporations. So a Delaware decision makes the governing law not only for half the corporations that are publicly traded, but also most other states have a tendency to follow Delaware case law.
These companies are in Delaware, presumably because it has a favorable climate for corporate law. Therefore, it could to some degree be in favor of management, could it not?
Well, that's a healthy suspicion, but I would say in this area for the last 4 or 5 years, the Delaware courts have probably been more favorable to the bidder than the courts of most other states.
Is a lot of money at stake for the state of Delaware?
Roughly 20% or so of Delaware's corporate total taxes come from its corporate franchise tax, and to that extent, Delaware has an interest that no other state does in maintaining a very large stable of corporations incorporated in Delaware.
Is this issue as simple as I've made it out to be? Shareholders versus management in a takeover situation?
Well, I think it's a little more complicated than that, Stuart. The Delaware courts have said that any time a board takes a defensive action in a takeover, they will review it to determine whether or not that action was reasonable in relation to the threat. And that gets us into a big question. What's a threat? What kind of threats really count? How much can you do when you have a small or a medium-sized threat? And that's where Paramount and Time are going to be disputing. Paramount is saying that the chancellor effectively allows any corporate management in the country predict that its long-term value is over the takeover premium and thereby defend itself and prevent all takeovers. Time says that's much too much. Nothing like that happened, and we were very reasonable.
John Coffey, will be hearing more from you about this issue when the hearings get underway in about a half hour. Thank you, Professor.
Mergers in this country. CNN's Stuart Varney joins us now from New York. Stuart?
Well, the Delaware Supreme Court is about to hear arguments in a case which has wide implications for the way takeovers are conducted. The court will rule on the attempt by Paramount Communications to block a merger between Time Inc. and Warner Communications. It is a battle between corporate managers and their right to manage as they see fit, and shareholders, their right to receive the highest possible price for their shares. Also significant is the venue, Delaware. That state is the corporate home to many of America's largest companies. It has a reputation of offering a favorable legal climate to management. So another question today is, how far will Delaware continue to be a safe corporate haven for managers? CNN's Terry Keenan is standing by at the courthouse in Wilmington. Terry, what's on the schedule for today?
Well, Stuart, the Supreme Court is expected to hear oral arguments for about 2 hours this morning. Paramount's lawyer will go first, and he will have the job of convincing the Supreme Court that the Time Warner merger is illegal under Delaware law. Graham Perry takes a look at some of the legal issues involved.
In this building in Wilmington, Delaware, the rights of shareholders and the responsibilities of corporate boards have been defined by the Delaware courts. Today, the Delaware Supreme Court will further define those rights and responsibilities by answering 2 questions. One, did Time put itself up for sale, for auction to the highest bidder, when it agreed to merge with Warner? The lower Delaware court said no, because under the merger agreement, Time didn't sell itself. Its management would remain in control of the new company. The second question was Time's later agreement to take over Warner a maneuver to defend itself against Paramount? And if so, did that maneuver also make business sense? Was it reasonable corporate policy? The lower court ruled that although Time's takeover proposal was defensive, it was also a legitimate business strategy, part of a long-term plan for the company. So the lower court decided the Time-Warner deal could proceed as planned. Most legal experts say the Delaware Supreme Court is unlikely to disagree. Experts also agree that if the lower court is reversed, if Paramount wins, the implications would be far-reaching, with hostile bidders gaining new powers in corporate boardrooms. Grant Perry, CNN Business News, Wilmington, Delaware.
The hearing should get underway in just a few minutes here on the third floor of the Delaware court. The courtroom is crammed with more than 100 Wall Street lawyers and arbitrageurs, many who had to wait in line last week just to get tickets to get in. This is Terry Keenan reporting live from the Delaware Supreme Court.
When must the board shift from its long-term maximizing profit motives to pursue immediate short-term values? And that I'm just echoing and adding to what Justice Moore said. And the court found that that you didn't prevail on that argument, and you don't resist that argument. So you agree that the board is still in a long-range mode of action, and it doesn't have to shift to immediate enhancement of shareholder values, and yet you're quarreling. So what you do is it comes down to a quarrel with what is the future value of Time discounted to a present value versus your witnesses versus the others.
Well, it's not our witness.
I don't think you answered my question about Mr. Snyder's letter of March 9, 1989, when he views it as the greatest deal ever imaginable.
Your Honor, first of all, I think, as Your Honor read the entire letter, it is a bit puckish, a bit tongue-in-cheek. But in any event, we do not question that Time Warner is a good deal. We don't question that.
Then don't you lose?
No, Your Honor, I don't believe we lose. Because what we do, you can have a good deal and you can have a better deal. And
But if we go back to the concept that we're analyzing this under Unical, and you've indicated Time and Warner is a good business arrangement, and your argument is Paramount may be better. And we take the principle that to a certain extent the board is recognized as someone who can be the intermediary between the stockholders and someone that wants to present another proposal. If we're really down to two business choices, why doesn't the board get the benefit of the business judgment rule here?
because the board did not follow what both Unical and Smith versus Van Gorkum told it to do. In Smith versus Van Gorkum, this court held that a failure to inquire is gross negligence. And this board...
Will perhaps be able to summarize exactly what the first three lawyers have been saying. Professor Coffey.
Well, Mr. Cantor for Paramount has been essentially raising the Unical argument. He says that the prior case law in Delaware requires the court to review closely and objectively the board's judgment that its long-term value exceeds the tender offer premium. And he's claiming that the Chancellor didn't do that the Chancellor engaged in only a good faith review, deciding that the Time directors were sincere. He's arguing sincerity is not enough, and that when you have a long-term judgment that your value will be at a certain level, you have to present value that. You have to bring it down to its value today. And that's been his Unical argument. Mr. Savet was arguing the Revlon argument, that this company really was up for sale, that the Time Warner transaction amounted to a merger and required you to put the company on the auction block. Paramount gave up on that, and the court was quite hostile to that. Mr. Klein finally was arguing, again for shareholder groups, that there's a duty to investigate, that the Paramount board, that the Time board failed to inquire with Paramount what it was willing to offer and to explore the best possible offer that it could get. That's a violation of its duty of care.
A quick question. It looks like these are very speedy proceedings. Are we going to get a decision today by the looks of it?
I can't promise that, but it's very likely. In prior cases, they've been able to do that, and this looks like a court that knows the way it's going on this case.
All right, we will stay with these proceedings and return to them and have more for you right here on CNN after this.
The cliffhanger, how did it come out, Justice Holland?
Well, it's interesting. This was broadcast live across the country, and we took a recess after the 2 hours of argument, and we came back at 2 o'clock to announce the decision. And so they were live across the country again. And in this very high-tech case, they lost the audio across the country. So when Justice Horsey announced the winner, no one knew who won until we left the bench and they could watch the faces of the attorneys, some of who are on this panel this morning. And so, to give it away, Mr. McBride was not smiling.
And that's
Actually, he
rare.
was
I'm
smiling.
always smiling.
David's always smiling. He was smiling. He was very gracious, if I recall, actually.
Ken, did you manage to get on TV?
Yeah, I was telling this story in prep for this. One thing I do remember was that I had a strategy for getting on this telecast, because I did not argue. And the strategy was to bolt out of my seat before the cameras were shut off and start shaking hands with the principal arguers. And it worked. If I recall, it worked. As again, everything is a little bit of a blur. I recall it worked. Or it might have been a different case.
You may have missed the other strategy, Ken, which was Greg Varello's strategy, your local counsel. Greg, who also represented Warner, of course, was prominently splashed across the front page of the New York Times the next morning, smoking a big fat cigar with a real, well, there's a description of his smile that I probably can't repeat here, but a grin.
I actually, in watching the video clip again, I thought the reporting and the way the reporter approached the issues really did simplify the issues pretty straight ahead. But one of the things that I heard Jack Coffey say was that in the last 4 years or so leading up to that argument and that hearing, that the Delaware courts had probably been more favorable to bidders and to the stockholders and to the management side. And that sort of prompted my thinking about maybe we should start by talking a little bit about what was the state of the takeover law when Paramount v. Time was decided back in the late 80s. And I'm just going to ask, it's going to be a little bit of free form, but maybe, Larry, maybe you could start by giving a little bit of an overview, and everyone else can join in and add their perspectives on sort of where things stood at that point.
Sure. This is 30 years ago. That's why we're here, on the 30th anniversary of the case. It's also like the 34th anniversary of Unical and Household, and 33rd or 34th anniversary, depending on how you count, of the Revlon case. But back in that time frame, 1985 to 1989, it was like a snow globe of case law. There are all sorts of things swirling around, and you just didn't know how they were going to settle out. So what was neat about this case, and I have a vague recollection of it even at the time, was an awareness of how much was left to be worked out from these massively important cases that had just come within a couple of years earlier. We'll all talk about our thoughts about those cases, but Unical was obviously the biggest one, at least as far as I was concerned. And it talked about the right and responsibility of a board to respond to a threat to corporate interests without really defining in any kind of comprehensive way, close to comprehensive, what a threat was. And that was Jack Coffey's point in the clip. So in this case, in Time, I think we all worried about, well, what's the threat here? As defendants, as representatives of Time and its directors, we had to articulate, I think, why we thought that Paramount's offer was a threat. Because after Unical, there was a respectable argument that if you're making an offer for all the shares in cash with a promise to do a prompt second-step merger, there's no threat at all. Just let the stockholders decide. So where's the threat? And there were a number of irons in the fire we'll talk about in terms of identifying those threats, but that was one thing that was playing out at the time. The other thing, which frankly I thought was a lot less important or serious, was the question of when a company is for sale, such that the board of directors is obliged to abandon its other strategies and simply look for the highest currently available price. Revlon, in other words. And what did Revlon mean and when did it apply? I'll just cut to the chase here and say, Dave, I applaud you and your colleagues. I did at the time, and I still do, for having the courage to recognize that, as I thought, that was not a great argument, and place your marbles on the Unical point, which I thought was a lot better. Two other lines of case law that were swirling around at the time were the Blasius case, 1988, Chancellor Allen's case, and we're litigating in front of the same judge. And one of the things that always disturbed me in this case, or gave me some concerns as a representative of defendants, was the stockholders of Time had, under the original deal with Warner, been afforded the right to vote on the deal, up or down. And that was a function of New York Stock Exchange rules, because Time was going to be issuing a big slug of its stock, and Stock Exchange rules required the stockholders to vote on it. And when Time recast the deal as a tender offer for Warner, that vote was no longer required by Stock Exchange rules. It was never required by Delaware law anyhow. But still, there was a little bit of that pulling the rug out from under the stockholders' sense, and one of the issues I thought was lurking there was, would Blasius, which was about the integrity of the stockholder franchise, be something that Chancellor Allen would come back to here? And finally, the other aspect of the new case law that was floating around was the poison pill cases. Validated in Household in 1985, but in just the year before Time Warner, in two cases, had been essentially struck down by the Court of Chancery, in the Pillsbury case and in the Interco case. Now, Time Warner, as it came to be litigated with Paramount, was not a poison pill case, but we were all intensely aware that, well, it was in the complaints, and we were aware that because of the impact of the Time Warner acquisition on the Paramount deal, there was a respectable argument that that was a similar kind of defensive response, and maybe those pill cases would come into play.
Well, that really covered a lot of stuff. Dave or Lewis or Ken, do you want to add a little bit on that front in terms of the state of play?
We were so lucky to be practicing and judging during this period, because there were, I think, three issues that sort of cut across all the cases during the 80s. One was legal, one was economic, and one was financial. And as I was rereading the opinions in this case, I saw all of them being discussed or addressed. One, the legal issue, you probably remember that tender offers were a relatively new invention. They really didn't exist, at least in the business world, until the late 70s, and then in the 80s they became a vehicle for a hostile offer. And the law was really, there was a lot of debate, particularly among academics, but also among courts, about how do you deal with a tender offer. Because one paradigm is you deal with it like what it is, an offer by one person to buy the shares of a stockholder. Under that paradigm, directors would typically have no role to play at all in the matter. It's for the shareholders to decide where they want to sell their shares or not. On the other hand, the effect of the tender offer was much more like a merger. And under the Delaware statute, if you treated the tender offer like a merger, the board had, in effect, if not a veto, at least had to approve the matter before it could go forward, before the stockholders ever got a choice. So one of the big legal debates was, where does the tender offer fit in these two paradigms? Are we going to treat it like an offer and the board has no role? Or are we going to treat it like a merger and say the board's got the ability to block it? Unical, to my mind, was one of the most brilliant cases the Delaware Supreme Court ever decided in the area of corporate law, because I thought it was a great compromise on that issue. It said the board had a role, but what the board did in response to an offer couldn't be preclusive or coercive or unreasonable. The economic issue, and you hear a lot of debate about this now, is what are the role of corporations? I remember one of the first takeover battles I was in with Wachtell Lipton and Larry. We were defending Phillips Petroleum, and we went out to Bartlesville, Oklahoma, to I forget why we were out there, but we were there to meet with management and plan a defense to the Icon tender offer. And the people there treated us as if we were knights in shining armor come in to rescue their town. And so one of the questions was, does a corporation have a social and economic purpose beyond or in addition to maximizing shareholder value? Now, the case law in the 80s gave predominantly one answer to that question, or at least it was perceived as, but that was, I think, one of the big issues in Time Warner. And now we're debating it again with benefit corporations and the Business Roundtable statement. The third issue was financial issues, markets. If you remember the Reagan Revolution in the 1980s, a lot of emphasis was being put on a confidence in markets. Deregulate the economy, let the markets work. Markets will produce a better answer than a regulatory answer. Well, that same issue was at play in the takeover arena because bidders were saying, let the market make a choice. The market will make the right choice. The market will make the best choice. And there was even a debate between efficient market theorists who said that all the future value that a corporation may have is reflected in its current market price versus what I'll call the Graham and Dodd intrinsic value theorists, which would say that markets are inherently irrational. They're sometimes over-exuberant and sometimes depressed. And the market price doesn't always reflect the best measure of value. All those issues were at play all through the 80s, and they're in these decisions too.
I could go back pre the period that Larry was talking about a little bit to set the stage as to, where we were. Before 1985, when a lot of these cases were decided, there were not many Supreme Court of Delaware important decisions which dealt specifically with the issues that faced us in takeovers. There was the business judgment rule. And this was the real, and I think really, if you went, all of these cases in a way can be viewed as putting a gloss or modifications or tweaking or whatever you want to say about the business judgment rule. And the business judgment rule essentially said that a board of directors manage the corporation, and B, if a board in good faith on an informed basis makes a decision, it will generally be upheld. And I remember in 1984, before these cases were decided, I worked on a matter called Thompson v. Enstar. It's not a very widely known case, although it is cited in many of the more significant Supreme Court cases. And Enstar had a lot of the same issues. And Vice Chancellor Hartnett decided the case, and I went back and I looked at the opinion. And the law is skimpy. I mean, it's just skimpy. There is a business judgment rule. There's law review articles being cited. There's some cases. But we all knew in this world that there was a landscape that had to be filled in with a lot of very much more specific decisions. And while Larry makes the excellent point that even after these cases, there were a lot of things to be still decided, before these cases, the arguments were really just the business judgment rule and cases which were perhaps analogous or you could glean things from, but not the on-point kind of decisions that we started to get around 1985. And in 1985, you had not only the ones Larry mentioned, you also had Smith v. Van Gorkum, which was on the duty of care of directors. So at that point, you had, Revlon, Unical, Blasius, Household, Smith v. Van Gorkum, And I think when Time Warner came up, it was viewed as a place where a lot of these cases were going to be applied to a very high-profile, major transaction and tender offer. And we were going to see what these things really meant. There was a lot of discussion, a lot of debate. What does Revlon really mean? When are you in Revlon, or when are you not in Revlon? And back in those days, and Time Warner was a place, all of those cases, put this way, set the stage for Time Warner. How is the court going to take all of these cases that are very, very new, and how are they going to apply it to a transaction and offer that everybody was looking at? I mean, it wasn't every day that you had an M&A case on CNN. This was a very high-profile situation. So that really, I think, sets the stage for where we were when the litigation started.
So just one point in terms of setting the stage, and immediately prior to this case, Chancellor Allen, who decided Time Warner, had decided the Interco case in 1988, just 6 months before. And on the subject matter of a threat, which was a major issue in the Time Warner case, in that particular case, there was a request by the bidder to have the company lift a poison pill. And at the court, the company had not lifted the poison pill at that point, and it had actually employed the poison pill to come up with an alternative to the transaction that was proposed by the bidder. But here is just to maybe set the stage for where we were and why Paramount may have thought they had a good shot here, that there really wasn't a threat. Chancellor Allen said, once that period of the board using the poison pill to come up with an alternative has closed, and it is apparent that the board does not intend to institute a Revlon-style auction or to negotiate for an increase in the unwanted offer, and that it has taken such time as it required in good faith to arrange an alternative value-maximizing transaction, then, in most instances, the legitimate role of the poison pill in the context of a non-coercive offer will have been fully satisfied. The only function then left for the fill at this end stage is to preclude the shareholders from exercising a judgment about their own interests that differs from the judgment of the directors, who will have some interest in the question. What then is the threat, he says in quotes, in this instance, that might justify such a result? He goes on to conclude, perhaps there is a case in which it is appropriate for a board of directors to in effect permanently foreclose their shareholders from accepting a non-coercive offer for their stock by utilization of the recent innovation of poison pill rights. If such a case might exist by reason of some special circumstance, a review of the facts here show this not to be it. The threat here, when viewed with particularity, is far too mild to justify such a step in this instance. So here was a case less than a year before the Time Warner case, before the very chancellor, who had said that in that instance there was no threat that justified at least the continuation of the poison pill, and that precluded the shareholders from making their own decision. So I'll just stop there. That Interco case was central for the plaintiffs.
Louis, that was perfect, because I was going to ask about that. I think at the time that Time Warner was decided, Larry had mentioned both Interco and Pillsbury, where the court had ordered effectively that a rights plan be redeemed. And I gather that there was some, let's say, turmoil, but maybe the academics and others sort of in the market maybe had been agitating for a different rule, and maybe things had swung, the pendulum had swung too far towards the shareholders' side of things as opposed to in the management camp. I don't know whether any of you have any thoughts about that in terms of what the environment was and what the pressures were at the time. I think Jack Coffey again touched on it a little bit as well.
Well, for one thing, and I'm glad you raised that, Louis, because you're absolutely right. That was very much in the air back in 1989, and it was the same judge we were in front of. We did, for Time and its directors, we did everything we could to wave our arms and say, Your Honors, this is not a poison pill case. And under the circumstances, what Paramount was most focused on, understandably, was trying to head off the combination with Warner. That was the major condition in their tender offer, and that's what they were trying to enjoin. It would have been a very different case if the only issue had been, can Time maintain a poison pill against Paramount? under those circumstances.
I remember after the decision came down, Steve Lamb, who obviously went on to become a vice chancellor but was then in private practice, asked me, why didn't you guys just challenge the rights plan? And I said, because we couldn't close our tender offer even if we got the rights plan out of the way, so long as the merger agreement, which gave the company no escape, was going to remain in place. I'm not sure, but what's interesting to me is, maybe we'll come back to this, our own CEO testified in the case when asked the question, is Time's acquisition of Warner, does that preclude you from acquiring the combined company? Said, oh no, it doesn't.
Best deposition question ever.
I got to say, when I came back to our team meetings after taking depositions and I heard that answer was given, I thought, there goes Unical, because it was hard for me to figure out how we could win Unical if we were conceding the merger didn't preclude our tender offer. But
so back at the time this case was litigated, maybe you can just sort of, again, before we delve into all the facts, how did you litigate these cases on such a compressed schedule? Like, what was it like doing this back? I mean, somebody made a joke earlier on about how there was no internet, but we didn't even have computers back then, did we? How did these things generally get litigated, and what did you do? How did you get things done?
We chiseled the briefs in stone and turned them in.
Well, I will say, I mean, one comment is that it's been said recently that the internet and email and text message and everything else, the speed with which you can communicate now has accelerated the pace of litigation. Obviously, emails increase the amount of discovery that has to be done, the document review, and how time-intensive it is, particularly in an expedited case. However, back then, this case, I mean, after the injunction was, the TRO was denied, there was expedited discovery, and I don't remember the exact briefing schedule, but the hearing, I think he issued his decision on July the 14th, 1989, and the hearing was maybe 4 days before that. So between June 7th or something and July 10th, there was 15, 16 depositions. There was briefing. And so I can say that, I mean, I was not personally involved in any of the depositions. However, every time, I was thinking this morning, how did we even get the transcripts? Because I think they were overnighted, or they were hand-delivered, copied and hand-delivered. So you didn't have the immediacy of, an immediate transcript and then get sent to you by a PDF. So there might have been a 24-hour delay. But all that was happening in real time. You kept processing the facts section of the brief that we knew we were going to have to write as we got depositions that kept coming in. And they changed really just about till the last moment, because the last deposition and/or last affidavit before the hearing, in fact, rereading the transcript of the preliminary injunction, their affidavits submitted the morning of the hearing. So it was a very fast-moving situation. But I will say that entire period, you mentioned, Ken, it was a blur. I mean, for my purposes, it started June 7th, it ended July 24th. When it was all over, I was thinking, well, it's the summertime now, start of the summer. It's time to go to Point and to the flower market and to the Greek festival. Then I realized that had already all happened. So you were wrapped up in this world of the facts of Time Warner. What was a threat? Were these defensive measures too punitive? Did Revlon? All that stuff. And it was happening on a very expedited nature. With respect to the Supreme Court hearing, just in terms of technology, it was so widely watched and so many people wanted to attend. And it wasn't just the lawyers, it was the ARBs. Because in this period from 1985 to 1989, even if you were not involved as one of the counsel for one of the parties, you almost certainly were involved for somebody who wanted to know your opinion. What is the Delaware court going to do? What is the Delaware Court of Chancery going to do? What is the Supreme Court going to do? Because they were going to trade and make bets based on your prediction of what the Delaware court was going to do. And it wasn't certain in all these cases. Were they going to enjoin the transaction because the target just said no, or is that a legitimate response or not? And how is that going to affect what the court's going to do? Just one brief story about how technology then was different with respect to those cases, including this one, and the desire, as Justice Holland said, about broader public wanting to know. They weren't only interested because they wanted to know what the legal doctrine was. They wanted to know what the final result was because it affected their trading strategies. There were cases where the lawyers for ARBs would be in the courtroom. Eventually, the rule was, you couldn't have cell phones, which back then were pretty big. You couldn't bring them into the courtroom. So I know that one group had a mirror, and the decision came on a sunny day, and he would come out and he tried to beat everybody else because I guess the speed of light is faster than the speed of a telephone. So it's like 1 if by land and 2 if by sea. He would sort of blank, merger granted or merger denied, and then somebody would get on the phone and make a trade. It was really unbelievable sense of urgency with each of those cases. And then once one ended, another one started.
Well, in that regard, as everyone said, this was a very exciting time, and technology was different, and people were watching the decisions. And there were a lot of cases being tried in chancery, and the arbitrators would frequently go out on the courthouse steps and make a sign like there was a touchdown, or do all sorts of things to bolt out of the courtroom. And the Delaware Supreme Court had to convene a meeting with all of the major law firms that were dealing with these cases and said, we need a little decorum here, and basically tried to get people under control because there was such an interest and such a premium on getting the answer out first or getting the prediction out first, and that we had to call a meeting of major counsel.
Well, my story that still rankles is I noticed that our main brief in the Court of Chancery was filed on July 8th, I think it was, consistent with what Lewis said about the schedule. And it was ridiculously long brief. And my most distinctive memory of working on this case is actually being in a conference room at Cravath, Swain and Moore, our New York counsel, with Bob Joffe, who passed away a few years ago, but I want to digress and give him a posthumous acknowledgement. He was the main litigator for Time and the directors, and was as warm and humorous and generous a lawyer as you're ever likely to meet. Wonderful guy to work with. Except for the fact that I was stuck in his conference room over the July 4th weekend, vaguely aware that there were these fireworks going on in the New York Harbor that we overlooked, and I wasn't able to pay the slightest bit of attention to it. Not that I have any grudges about this or anything, but that was my July 4th holiday in 1989.
Well, in an earlier case, I worked through the Super Bowl. It was a very exciting Super Bowl, which I missed. These cases back in those days simply required a Herculean effort on the part of the lawyers. And I'm not saying it only happened back then, but I mean, you can talk about how you did it, et cetera. It simply required an enormous amount of work. But I will say that at a later phase, this case, Time Warner, like many of the cases back then, there was no trial. This was a preliminary injunction. There was no evidentiary hearing. It was done on the basis of depositions, affidavits, documents, briefs, and then an oral argument. And I would never minimize the amount of work that it took to get there. However, later on, it became more of a fashion to do this on the basis of an expedited trial, not on a preliminary injunction motion. To some extent, some of the timetables had slowed down a little bit. And also, from a litigation strategy point of view, I think people came to understand that there was no substitute for having your client actually get up there in the witness box and testify, as opposed to having these things done on a cold record. And as difficult as it was to do this in a compressed time schedule on a PI motion with no evidentiary hearing, once we started to introduce the expedited trials, that really was quite a bit of work. And it still happens today. Maybe it was a few weeks longer, but putting on the trial and preparing for trial and handling the trial was unto itself. So it is interesting to think back from a litigation point of view about the fact that all these famous cases that we talked about were done without trials. They were done really on the basis of an oral argument. And that the depositions in some ways became more important because the witness would never have an opportunity to be out there again. And the advocacy was shorter, briefer, and you had to be really adept at doing that. And some of the people who, Herb Wachtel in my firm, Bob Jaffe, who in this case, Mel Cantor, all the people, they were really great lawyers who really did a great job of in a short period of time, conveying the issues and arguing the matter.
I think the expedited cases from the plaintiff's side was a real frustration because on the defense side, the defense was already prepared. It was in the can, so to speak. And what the story was going to be had been set in the boardroom, and the arguments had been anticipated. On the plaintiff's side, you have to break through that story. And it's very difficult on an expedited basis to get the facts. In fact, after the case was over, the general counsel at Paramount sent me this book, To the End of Time. It's written by a Time reporter and former reporter and executive about 3 years after the case. And he had time to go and interview people and review documents perhaps more extensively than we did. And I got to say, if we had been able to put on the case that's described in this book, we might have won the case. But I think from the plaintiff's side, the expedition is a disadvantage. And the other thing that happens to you is you get filibustered. I remember taking the deposition in this case of Jerry Levin, who was then the vice chair of Time and really the mastermind of this transaction, went on and became the CEO. And it seemed to me like any question I asked, like what is your name or where did you go to college or whatever, I got a lecture on the Time culture that went on for 10 minutes. And if it didn't do anything else, it used up the time I needed to ask questions. So.
Dave, that is an unbelievably timely segue. I wanted to talk about the Time culture a little bit. I know one of the, and we're not going to hit all these slides in precise detail, but one of the things that was part of the record in the litigation, and there was quite a bit of it in there, was related to one of their goals being to maintain the company culture, or what became known as the Time culture. And I actually thought there was a very interesting footnote. I think I mentioned it before, that it's in the Supreme Court opinion where the court, footnote 4, where the court says, the primary concern of Time's outside directors was the preservation of the quote-unquote Time culture. They believed that Time had become recognized in this country as an institution built upon a foundation of journalistic integrity. Time's management made a studious effort to refrain from involvement in Time's editorial policy. Several of Time's outside directors feared that a merger with an entertainment company would divert Time's focus from news journalism and threaten the Time culture. So why don't you all tell me a little bit about this Time culture, and was it real? Was it a litigation construct? What was it?
I think it was. I think there was legitimate. There was some truth to it. I'm sure Time did have a culture, and I'm sure journalistic integrity was a part of that culture. But what frustrated me most about the argument on Time culture was the history of Steve Ross, and in particular, the fact that the Time board really didn't investigate Ross. And Ross had, as this book is fascinating in terms of what it describes, but there was a report done, there was a federal investigation involving organized crime and other corruption. A number of people were convicted, and at the time, the U.S. Attorney for New York said, according to this book at least, that Steve Ross was was an unindicted co-conspirator and should have been indicted. They never did indict him. The Board of Time created a special committee to investigate this matter and several other matters that Ross was involved in. That investigation went on for 8 years, produced a 688-page report with something like 80 exhibits, was actually the subject of a books and records case in Delaware Court of Chancery before the Time Warner case, and that case was before Chancellor Allen, where one of the directors at Warner was trying to get access to the report because the report wasn't even shared with the entire board. And this book actually quotes part of the deposition the ineffective deposition, I will say, that I took on this subject, but it lays out the differences between the extent to which Ross was examined by the Time Board and the extent to which the CEO of Paramount was. Because after Paramount made its offer, at least according to this book, Time hired Kroll Associates, the private investigating firm, to try to find dirt on Paramount's CEO, and in fact was making allegations, and there were rumors, according to this book, being spread. But the idea that time culture was the most important thing to the board, and that time culture was worth trading shareholder value in order to preserve that culture, which is what happened here. They actually gave Warner a better exchange ratio on the original merger in order to get the employment agreement that the Time management wanted. The idea that time culture was worth preserving and paying and surrendering stockholder value for, when the person that you were going to make the CEO of the company, you hadn't really investigated their background, to me was just infuriating.
I gotta, in defense of Steve Ross, I mean, first of all, this does show you how difficult it is for people who are plaintiffs to crack through and make their case, because they have to reach for things like what Dave just said. The investigation he's talking about never went anywhere. Steve Ross was the founder of what was then called the modern-day Warner Communications. In 26 years, Warner's revenue grew from $17 million to $4.2 billion under Steve Ross's stewardship. He was a revered figure. He had the most extensive relationships with people in the business like Steven Spielberg and Clint Eastwood, and really major, major figures at that time. He was viewed by Time, and I think Larry can tell us this because he's the Time representative, as an enormous plus for this deal. The whole idea of the deal was that, looking to the future, these companies felt that they had to have an integrated media company that included entertainment, journalism, all these different things, because that was going to be the wave of the future. And Steve Ross was viewed as a tremendous asset, not a liability, as Dave would have it be. And so he was, I met him a few times, he was a great figure, and I think he was, as I just put it, an asset, much more than he would have been deemed a liability at that time.
So, Bill, I want to go back to your question about...
I have a rebuttal, by the way, but I'll save it.
Oh, no, sorry, I should give you a rebuttal.
No, that's okay.
You asked about this time culture and whether it was real or a legal construct, and Dave was questioning why Time and its directors would give up value in order to preserve it. And that raised a bunch of questions in my mind at the time.
Do you want to maybe pick up where we were on the time culture?
Yeah. Again, you were asking about whether it was real or a litigation construct, and I think the answer was it was real. My sense was it was very real in the minds of Jerry Levin and the Time directors. And in hindsight, I kind of get it, that in an era where news outlets are frequently more opinion outlets than news outlets, the idea of avoiding commercial pressure on a news organization seems like a good idea. However, I want to say a couple things about how I thought about the time culture issue at the time. I found it very difficult. On one hand, I really did, to some extent, believe that the directors reasonably believed that preserving that culture was not just something to protect journalistic integrity, but it also had a financial consequence, a positive financial consequence to Time and its stockholders, that there was some real economic value in keeping that culture in place. At least that's what I thought early in the case. And I thought, this is a good horse to ride because, if you're thinking about Unical and what's a threat here in terms of the Paramount offer, the threat is to the Time culture and whatever values it supports. And I thought that so much that I ran into Dave McBride on the way to some probably non-consequential oral argument or chambers conference or something, and I felt like tweaking him. So I said, Dave, what's it like to represent the Beavis and Butthead, which of course was a Paramount property? And I was sort of feeling holier than thou because we represent Time and the Time culture, journalistic integrity. And Dave shot back, because he's a pretty quick thinker. Yeah, and you represent People magazine? So I was duly chastened. And you should never have done that, Dave, because not only was I chastened, but it made me a little more skeptical about how far and how hard to ride this Time culture horse. And I remember we had internal debates about, is this the biggest and best thing we've got? Or should we be a little more circumspect and more emphasize the value creation aspect of it? And I was much more in the latter camp. And if you read Bill Allen's opinion, Chancellor Allen's opinion, he is very cautious and very deft about how he handled the issue. He recognized that it was something that Time and its directors believed in, and how it might have had some value, but he was also cautious, and I think this is something you've got in the slide here about just under that.
Yeah.
Maybe not. Yeah. Maybe not quite.
No, maybe
First
later in the
draft.
slides.
Earlier
actually.
draft.
Well,
But in his opinion, he says, one has to be cautious about how much credit you give to corporate culture as a threat, because basically you can almost make up anything and claim that it's your culture. Bottom line is, I think there was some truth to it, but it was not a truth that I felt was going to get us all the way home in defense of the Warner acquisition.
So to that point, first of all, I would commend everyone to read Chancellor Allen's injunction opinion just as a model of common law jurisprudence. I mean, he makes his decision articulating what is the standard, what's in the record, and what do I think this record compels me to do. On this point, he went out of his way, first of all, to recognize that directors could, in good faith, believe that the Time culture was important, and it doesn't necessarily reflect any bad faith that they're feathering their own nest. They just identify with the Time culture and its larger role in American society. But whoever was on your side writing the affidavits for the outside independent directors, he also quotes one of the outside directors who, after talking about the importance of Time's editorial freedom, goes on to say, that feeling on my part coincides with the interests of the Times stockholders. The editorial integrity I value is also a tremendous source of value to the company and its stockholders. Without it, Time magazine and the company's other magazines would lose their loyal readers and advertisers, and Time's revenues and value would suffer. The governance provisions were necessary to ensure Time writers and editorial personnel that editorial independence would continue to be respected at Time. Otherwise, the integrity and ultimately the financial viability of the institution would be threatened. So that was the record, and on that record, and others said similar things, he thus concluded that even though the Time culture, subjectively, the board viewed it as important to American society, what was most important for him was there was an insufficient basis to suppose at this juncture that such concerns have caused the directors to sacrifice or ignore their duty to seek to maximize the long-term financial returns to the corporation and the stockholders. So it was very well done.
Very
lawyer.
understated.
No, I know, but it was very deft, as you say, but also he honed in on the fact, and that's what Unical said also. You can consider the effect on other constituencies as long as you're weighing the effect of those constituencies as it affects stockholder value. And I can tell you at 4:30 in the morning, writing our briefs on this interco point about what's the threat, we didn't really have an answer to those points in Unical.
I'm going to sort of just briefly, so the state of play in the time of this was Time had a lot of anti-takeover protection, I guess it's fair to say. They had a staggered board, they had restrictions on action by consent, they had advance notice bylaws, and they had a pill. Now, there was a lot of talk about the Time culture, but maybe, Ken, you could give us a little bit of background about Warner and why it was that it was, such a good company. I mean, I think you said a little bit about Steve Ross earlier, but maybe you could give a little bit of background about Warner and what they brought to the table here.
They brought a lot to the table. If you just look at these companies, and I'll go through a sketch of what the company's businesses were, it's just a very natural fit. Time, obviously, was in magazine publishing. It published Time, Life, Fortune, Money, People, Sports Illustrated. It was had cable systems, including in New York City. It had HBO. It was, I think, the largest cable programming service, and it had a significant presence in book publishing. Warner owned Warner Brothers Film Studios, and it was the only film company that had its own international film distribution business. And one of the things Time was very attracted to was the ability to use Warner's international presence for its own business. Warner was the second largest record company in the world, and there too had a large international film distribution business. Warner was a leading publisher of music, sheet music. Warner, and here's where you start to see some of the real closeness. Warner also owned cable systems, and in fact in New York City, Time was in Manhattan, had the cable for Manhattan, and Warner had Brooklyn and Queens. They both had a large investment in Turner Broadcasting, and together they would own something like 17% of Turner Broadcasting. So I think what Warner brought to the table was a really clear fit with Time. In terms of what Warner brought to litigation, that I know a little bit more about. And I just make 3 points. One is that we, along with Richard Slayton and Finger, we argued all the same points that Time did. The fact that we were Warner didn't prevent us from talking about the fiduciary duties and taking on really the whole thing, which we did. Secondarily, there was a kind of boilerplate. Warner, you aided and abetted this breach of fiduciary duty, which I guess is used to get us into the case, because they want us in the case just in case there is relief. All parties are before the court. And of course, the aiding and abetting claim, I won't disparage it any more than it's obvious on its face, but at the end of the day, this was an arm's length negotiation, and since there was no breach of fiduciary duty, there couldn't be an aiding and abetting of breach of fiduciary duty. But Warner had one more role in this case that I thought was pretty important. As was discussed, the deal changed, and the deal originally was a stock merger, and then became a time tender offer for 51% of Warner in cash, $7 billion. And again, these are preliminary injunction cases, and in preliminary injunction cases, you have to show that the plaintiff would suffer irreparable harm if the injunction is not granted, and you also have to show that the balance of hardships points in favor of granting the relief. That's what the plaintiff has to show. And in trying to counter that balance of hardships argument, we pointed to the hardship to Warner and its stockholders if this transaction was enjoined. This is not a case about the Warner stockholders. This was a case about the Time stockholders. However, it's always a good idea to give the court the full picture of what's going to happen if they grant this kind of extraordinary relief. And even though that was not something that was dealt with in the opinions, what was going to happen to the Warner stockholders, I think it gave a very real-world picture to the courts as to, the fact that this was a really good transaction that Paramount itself called a good transaction, involving a lot of money, and that if you mess this up, it may not be that easy to put back together. And I'll just make one more point, which I don't know that we've really touched on yet, but maybe we will going forward. The Paramount offer for Time was highly conditional. I don't know why they had to structure it this way, but they did. It was conditional on the merger agreement going away. It was conditional on a stock swap agreement, separate agreement that Time and Warner had going away. It was conditional on all the regulatory approvals being granted to Paramount, and I don't have the words here, but essentially, and Paramount in its own discretion has to determine that these approvals are appropriate and not on conditions it doesn't want. It gave a lot of discretion to Paramount to decide whether the condition was met or not met. It was conditional on financing, at least initially. I don't recall if that was the way it was all the way through. And, you juxtapose that to the Time Warner transaction, which, as recast, was not very conditional. And, we could show a real-world picture of this that I think was very favorable and perhaps helpful in the decision. Now, it's not having the more conditional, less conditional is not always a winning argument, but in this case, given all the surrounding factors, I thought it was, and the conditionality was something that played into that argument.
So let me just go back for a minute. I want to talk a little bit. So you have a situation where at the time they enter into the original deal, Time had already looked at various alternatives. I know we summarized some of them on one of our slides here. So they had done some diligence in looking at other companies, including Paramount, and made a judgment to sort of do a deal with Warner. Larry, maybe you could just briefly tell us a little bit about what the original deal was. I know, Ken, you touched on it, and then we'll talk a little bit more about the shift in the deal later on after the Paramount offer comes along. But maybe you can give us a little summary about the original deal with Warner.
Sure. I mean, it had some interesting aspects to it. I mean, at its simplest, it was a stock-for-stock merger in which Time, as I said before, would issue a bunch of its stock, and Warner shareholders would end up holding shares of the combined company.
And the Warner shareholders, as I understand, were going to own a majority of the combined company at the end of the day, like 60%, I think.
62% is the figure that came out. I've always resisted that point because that's what people argued to show that Time Warner had been sold. At the time, rather, had been sold, and that's what triggered Revlon. The 62% is misleading because there was quite a large percentage of shares of both Time and Warner that were owned by the same people. In fact, one of them gave us a wonderful affidavit saying how great that the Time Warner combination was. But the point was that, as we now know, as established law came from Chancellor Allen's original opinion in this case, the Warner stockholders and the Time stockholders ended up holding shares in a disaggregated mass of freely traded shares on securities exchanges. And so there wasn't a controlling shareholder that ended up, and it's not like Warner ended up being a controlling shareholder at Time. And there was overlap. So the 62% I've always thought was a little bit overblown as a figure. But the question is, what was this original deal like? It was a stock-for-stock deal, and there were some very closely negotiated, contentiously negotiated governance arrangements. And this goes back to the Time culture business, because there were specific allocations of how many seats on the combined companies board Warner got and how many seats Time got. And so as a result of that, in fact, some of the Time directors were invited to and agreed to resign to make room for the requisite number on the combined companies board. And there were specific plans about how executive succession was going to work. You could perhaps question why it was that one of the most successful executives in history, Steve Ross, ended up being put in a position where he had to step down after a few years. But that was the deal, and one of the aspects of it was to make sure that the Time journalistic integrity culture would be preserved. So closely negotiated. As I said, you needed New York Stock Exchange required stockholder approval for it, and that was the state of play as of just before June 6th when Paramount came along.
And by New York Stock Exchange approval, you mean for this? You need a stockholder vote.
Yeah.
Yeah. Okay.
And there were two other aspects of the original deal that didn't survive the recasting of the deal. One was that because it was a stock-for-stock deal, the surviving company wasn't taking on a lot of debt. The other was that under the accounting rules at the time, if you did a cash transaction, you had to book the premium that you paid as goodwill on your books and then amortize that every year. And that cut into your earnings. In fact, I think but if you did a stock-for-stock deal, you didn't have to do that. So switching from a stock-for-stock deal to a cash and stock tender offer by Time for Warner lost those two major business advantages to Time. I think the other thing that happened in the recast deal, at least my recollection of this is vague, but I think this is correct, the governance provisions in the original deal had a ring fence provision to them, so they couldn't be changed except by supermajority vote. That provision, the supermajority vote provision, got eliminated in the recast transaction. I remember we pointed to that as another reason why the Time culture and governance arguments were not as compelling. And I should also, let me just go back. I don't mean to criticize Steve Ross. What I mean to say is that if the journalistic integrity of your business is a major factor in moving the transaction forward, you would think that you would want to get to the bottom of whether the investigation that occurred revealed either criminal activity or ties with organized crime. And that argument never got made from our side.
They said like a country lawyer, I don't mean to criticize him, but I think he's a crook, right?
No, I don't. Really, I don't. But I don't think that Time culture is your big factor. You can just ignore that, which is what happened.
I take it, Dave, your view of the Time culture was just, that was code word for management entrenchment on the Time side?
Well, it was more subtle than that, because we had a document, and again, we didn't make much of this either. And I learned from this book why we didn't make the Armstrong report argument. A truce was declared. When Paramount made its offer for Time, as I mentioned to you before, Time hired Kroll Associates to investigate Paramount and was making accusations with respect to the integrity of Paramount's management. Paramount started to shoot back in a complaint that it filed in district court in New York with respect to including raising the Armstrong report. This book reports that a truce was agreed to where both sides would no longer make those kinds of attacks, and therefore the argument that I'm articulating about Time culture was not made to the Court of Chancery or to the Supreme Court. And I don't think either court was perhaps even aware of that issue.
I wanted to say a couple more things about the original deal, because I neglected to mention some interesting aspects of it, and I actually have a question for Dave and Louis about it. As a way to help assure that the deal got done, there were what has come to be called deal protections in that original agreement. There was a stock exchange agreement which would provide that no matter what happened, if the deal went off the rails, that Time would become a significant stockholder in Warner, and Warner would become a significant stockholder in Time. And that kind of trigger, like the no-shop provision that was in the original agreement, was the kind of thing that looks like you would care about if it were a Revlon case. And so what I was wondering was, I mean, you guys brought your complaint before Time recast its deal.
Right.
And I imagine that Revlon was going to be the centerpiece of that complaint. And I assume you brought it.
No, the original?
The original.
I don't think my recollection is that we had made the judgment early that we didn't think that Revlon was triggered.
Well, there was this TRO attempt against the exchange agreement early on.
Oh, well, the exchange agreement was a Unical claim, because what the exchange agreement did, and it was actually effectuated, is it gave, I think it was Warner 11% of Time and Time 9%.
I think combined it was 11%.
Well,
I think combined the swap was 11%.
No, well, at least according to the opinion, they say that
It was 11%.
Warner would have 11% of Time, and Time would have 9% of Warner. And that agreement was actually effectuated. And we were trying to, my recollection is we did attack that because that was one of the conditions to our tender offer going forward. The other reason why the merger agreement was a condition to our offer is my recollection is the merger agreement had no exit to it. And especially in the recast version, the Time offer for Warner, Time, I think, was obligated to go forward with that regardless. That's the "we're strapped to a rocket" phrase that was mentioned. And therefore, if the effectuation of Time's tender offer for Warner precluded the Paramount offer, then we needed to get that merger agreement invalidated. The problem we had was that our CEO, as I mentioned, testified that it wasn't an obstacle to Paramount acquiring the combined Time Warner, and so as both the Chancellor and the Supreme Court focused on that as a problem with our Unical argument.
And there were some other things in here, Larry. I know in reading the opinions again, I even struck me that someone who's been around this now for 30 years, dry-up agreements that were involved in the transaction. What were the? I mean, I know what they are now, having read it, and I was actually shocked when I read that they used to do these.
Yeah, well,
why don't you tell us a little bit about them?
That wasn't one of our better facts.
Yeah. What is a dry-up agreement?
Just going to a bank and saying, you got to promise us that you're not going to finance a hostile tender offer. Dry up financing is the source of the term dry up. And so there were a bunch of those, I don't know how many, but with multiple banks and sources of financing, all to, again, to protect the original Warner deal.
And at the time, so in March of 1989, after all the work that Time had done, they enter into the deal with Warner. But are people on the Time side are they worried about another bidder coming in? And did they know that Paramount was kind of lurking out there? And I mean, what was the state of mind at that point when you're signing up this agreement?
I can't account for everybody on the Times side. I know from where I stood, as far as I heard, there was no apprehension or expectation that Paramount would come along. But I think there was, given the atmosphere at the time, a concern that somebody might come along and make a bid.
So, Larry, on our side, I mean, I know the shareholder plaintiffs were making an argument that Revlon was triggered because now a majority of the stock after the original deal would be in the hands of Warner stockholders, and so that was a change of control. There should have been a control premium. You're now in Revlon mode. We didn't think that was going to be a very successful argument, so while we made it, we didn't emphasize it. But the court gave us credit for a more subtle, although rejected argument, and that was that original transaction was going to result by design in a company that was so big and so massive. As a practical matter, there could not be anybody who could ever take over the combined entity. So now, if this board doesn't fully investigate alternatives, and remember, I mean, the conditionality, I think, was a major problem for the Paramount deal, and probably in the minds of the Supreme Court, because you didn't really have a bird in the hand, and who knew you could save $300 a share, but if it was fully conditional on maybe we won't agree that enough of these stations have gone along, and we're not happy, and so who knows how long that was going to take. And now you're going to put at risk a carefully considered 2-year process that had major strategic benefit over the long run. But our argument was this company, it would take $30 billion because that was going to be the combined value of the new entity. And so who was going to come around in the foreseeable future? As a practical matter, if we don't get a control premium now, you're depriving it of the Time stockholders of that forever. And to the credit of the Supreme Court and Chancellor Allen, they both said, well, you know, it seems like a lot of money, but in today's capital markets, that can be raised. And then you had the great deposition question where Martin Davis said, maybe we'll bid for the combined entity. So the idea that as a factual matter, somebody once said there's nothing worse than a theory destroyed by a fact. And as a factual matter, there was a record that, you know, even Paramount might potentially bid for the combined entity. And there was the RJR Nabisco case that I think was a $10 billion transaction at the time. So that undercut that argument. So on our side, we were placed a lot more emphasis on Unical and the failure of the board as a process matter to really adequately investigate and determine what the threat was and to consider alternatives.
I have a question for, I'm sorry.
Let me just chime in on the share swap agreement. You know, this was part of the original plan where...
By the way, in the opinion, I think they refer to it as the stock swap lockup or something like that, but we didn't do that in the slides.
My point is that if it was a lockup, it was a pretty weak lockup. I'm trying to come up with some glib remark about a half lock or whatever, but it wasn't much of a lockup. And this was, as Dave said, this is part of sort of a first round of litigation that took place before the deal was changed. And then, you know, it didn't go anywhere. And we put in pretty extensive papers explaining from Warner's perspective why this was an important feature of the deal and how it really would have no effect on the ability of another bidder to come in. One aspect of it was that it was triggered, not so much, I think, if the deal went off the rails. I think it was if someone else came in with an offer. And it was felt, you know, that there were a lot of costs to just going into this transaction, which I won't get into, because just to make this not super complicated. And if somebody came in with an offer that was acceptable and that was accepted, This way, there could be a sharing of that premium benefit by these parties, by the one that's not in that offer. We didn't know who the offer would come from, for which company it would be. And it was a subject of litigation. There were a lot of explanations made for it. I don't really think it was a lockup, and if it was really, I would call it a crummy lockup.
Dave?
I wanted to ask Justice Holland a question, if I could. I mean, we've let him sit here silently, but this is a great opportunity to learn about what goes on behind the curtain in a way. But it involves Revlon, and it may jump ahead a little bit, but do you mind if I ask?
Oh.
Chancellor Allen, in dealing with the Revlon issue, said that Revlon wasn't triggered because there was no change of control. The Supreme Court, in addressing the Revlon issue, at least if my recollection serves, said Revlon wasn't triggered for a different reason. I'm not sure whether the Supreme Court rejected change of control as a basis for triggering Revlon or not, but indicated that there was no breakup or dissolution of the company. The corporate entity was going to be preserved. Was there, and that issue then came back to the Supreme Court in QVC 3 years later. But what was the court saying that change of control wouldn't have triggered Revlon, or was it? What's your?
No, I think Lewis has the opinion here, and I'll talk, later this morning about the dynamics of writing the opinion. But that was something that was debated among the panel, and in that section of the opinion, well, let's step back. We've talked about Revlon Time and Warner coming together, and if you imagine there were 100 shareholders, and partly Time, partly Warner. And the argument was that after they were merged, 62 out of the 100 would have been Warner shareholders, and therefore there was a change of control because 62% used to be Warner shareholders. And the fact is they were all unaffiliated. We'll assume that hypothetically. So to the extent no one person had more than 50%, there's no change of control. So in this section of the opinion, what we say is, the Chancellor concluded Revlon wasn't triggered because there was no change of control. And the sentence that Dave glossed over and everybody omitted that got us later to Paramount and QVC is the Delaware Supreme Court said, and the Chancellor was correct. Revlon doesn't apply because there was no change of control. Then we say, but we're not going to decide it on that basis. We're deciding it on the basis that a breakup was not inevitable. Now, we can talk about the reasons we wanted to say that rather than change of control, but we definitely said we agreed Revlon didn't apply because there was not a change of control, but we wanted to decide it differently. So we mentioned Paramount and QVC, which was decided 4 years later in 93. And in that particular case, what you find is Paramount coming back in, and it wants to do a deal with Viacom, and it says it's got a plan, and it wants to stick with its plan. And its deal from day one with Viacom was a change of control. So once you agree to a change of control, you have to deal with Revlon, not Unical. And that's what confused Paramount. And they were confused by not reading the language in the Time decision carefully.
Uh-oh.
Lousy Delaware lawyers.
So just Paramount kind of got it coming and going, I guess.
One big point atmospherically in this period of time was, I think, a major issue that the Delaware courts were confronting was, first of all, the Delaware corporation law is director-centric. 141, the directors manage the business and affairs of the company, not the stockholders. They obviously have fiduciary duties, but the directors manage the business and affairs of the company. Revlon, if you are in quote-unquote Revlon mode, then you have a very specific obligation, which is to run the company for short-term value maximization, period, end of story. So who gets to decide, or what are the circumstances that requires a board to, instead of considering all alternatives, use their good faith judgment for what's going to best maximize the value of the stockholders over the long term, that all of a sudden they have to do something different. So what was going on here, I think, was that what Time, I think, understood that when they announced this merger, it was going to be very public, and who knew who was going to come out of the water. And the fact that Time was looking to do the merger, the fact that it was structured in a way that 62% of the stock would now be held by Warner, would it be viewed in the market as being in play? And what the Supreme Court, I think, was troubled by, and ultimately Chancellor Allen, just because the Time board and other people thought that people might have thought the Time was in play, the board had not made a decision to sell itself. And the board had not made a decision to bust itself up. So the fundamental structure of Time was the same. They were just embarking on a transaction that was going to maximize value in the long run. So the mere fact that they engaged in that transaction, that once it was publicly announced, people thought it might be in play, they did not want to say that then required the board, or that mere fact meant that the board lost its ability to determine whether the company was actually for sale.
Larry, you had mentioned, and actually I think it was mentioned in this by Justice Moore in the Supreme Court argument in the clip that we saw earlier, a document from the case right after. I guess this is a letter that was in the record that was sent to the CEO of Time shortly after the original deal was signed up. Could you? I know you had pulled it out and said this was one of your favorite documents. Why is that? And
because it was our case. Yeah. In a word, it was really our case. If you look at our brief in the preliminary injunction in Chancery, it was the first fact we cited. And
the greatest deal ever imaginable.
The greatest deal ever imaginable. This is a senior Paramount executive, a head of one of their major subsidiaries, writing to a buddy at Time saying, fear and trembling strikes when, not very literate, I guess. Fear and trembling strikes when we view your colossus. And it was hard to read this as anything other than a recognition from the Paramount side that the Time Warner deal was a really good one. So you heard Mel Cantor earlier in the oral argument at the Supreme Court saying, no, we don't quarrel with the fact that the Time Warner deal is a good deal, which got us, I thought, way far down the road in terms of establishing what we needed to establish for Unical purposes, that we had something worth protecting, and that a Paramount offer that was a threat to that was a threat that the directors could consider. I mean, everything else, I think, flowed from that document, which is why it's been a favorite, and was a favorite of ours at the time.
So so Simon & Schuster at this time was
Paramount subsidiary.
Was Paramount subsidiary. So then a couple of months after the deal gets signed up, I take it that for a couple of months, Time and Warner are working along, trying to get their regulatory approvals and other things that are necessary and heading towards a stockholder vote.
Doing the proxy statement. Yeah.
So all of a sudden, June 7th, Paramount comes out with its original offer, $175 per share. And at a point in time when the Time stock was trading at a little over $100 a share. So the premium was, I guess, massive by any standard. And then you all had mentioned some of the conditions. And I think, Ken, the language on the conditions was that these were, Paramount got to determine whether the conditions were satisfied in its sole discretion.
In the one case of the approvals, regulatory approvals, that was the way it was worded. I'm not sure it was in the other cases.
Was given just the massive size of the offer and the conditions, was there a feeling on the Time Warner side and maybe just more generally in the market that this offer wasn't real, that it was really illusory in some way?
Yeah, in short, yes. And I'll never know, and Dave can disagree strenuously, and maybe he's right, but the timing of this and the conditionality of the offer and the letter put together gave me a sense at the time that Paramount viewed the Time Warner combination as a threat to them, and that once they saw that that Time and Warner had put their poke down and put out the proxy statement and were heading toward a meeting, the best strategy for them was to disrupt it. And what better way to disrupt it than put out this massive offer that was a remarkably high price, to be fair. I mean, I know that the bankers for Time came back and said, well, if it's a sale of the company, that's still not a fair price. But it was eye-catching, to say the least.
For purposes of the exchange ratio in the original transaction, what was Time valued at per share, if you remember?
Let's see, how did it work out? I don't remember the numbers, but it was a lot
Less than
what's-
175 by
far.
a lot.
Yeah.
Like maybe, I don't know what it was.
Dave, do you want to comment on the initial offer and just your take on, was it real? Was this more of a disruptive play? What was it? I mean, on the Paramount side of things.
I have no reason to think it wasn't real, but I do agree that there was a perception that, in one sense, I almost felt like it was too good to be true kind of offer. That the 175 and then the $200 offer were almost too good to be true, and one effect of making the tender offer, and I think this might have been part of what angered Time about the fact that the offer was made, was that it ended up forcing Time to, when they restructured the deal, take on a lot of debt and take on and have to book goodwill on their balance sheet, which would adversely affect their earnings for a considerable period of time after the deal was consummated. And so I've been in situations where parties have thought that the bidder was making the bid for the purpose of, if we don't win, at least we force them to restructure their deal. I have no reason to think that was the case here, but Time obviously did.
So the same day that Paramount launches its original offer, you guys ran into court, Dave. Do you recall, were you involved in the initial skirmish for, when Time ran in to seek the TRO initially?
If we lost, I must have been there.
I wasn't there because I thought, wasn't it ex parte?
Well, it's interesting. They tried to go in ex parte, but I believe that you guys actually showed up. And what I believe happened, and you guys can correct me if I'm wrong, but I believe what happened was the chancellor said, look, I'm going to give the defendants a chance to respond. And then you had another hearing, I don't know, a couple of days later, and eventually the court said, yeah, I'm not deciding this TRO basis. There's not enough of a record before me.
I think what he decided is that it was to enjoin the share exchange, and he said, I've got all the parties before me. If I ultimately decide that this is invalid, I can just force the parties to rescind it. I don't need to enjoin it.
Yeah,
No irreparable harm.
Yeah, no irreparable harm.
Okay, and that's right. So he denies that effort, and then a little bit after that, what happens? So a week later, Time rejects the Paramount $175 offer. They basically say they're going to stick with their strategic goals of going forward with their deal with Warner. And then Time and Warner recast their deal. And so what was going on in this time frame, Larry, in terms of why it is Time and Warner recast the deal, and where were the pressures? And by the way, Louis, not to leave you out, but at this point, had you guys gotten involved in the litigation front?
We were involved. We didn't actually file a complaint. I was just looking at it till June 26th.
A little bit later. So Larry, why don't you talk to us a little bit about, and Ken, you can chime in as well, why at this point in time did things get recast?
Yeah, well, I wasn't in the back rooms, in the boardrooms where this was being discussed and the strategy was being developed, but I think it was pretty clear that when you saw what happened to the stock price after Paramount announced its offer, and you see that the stockholder meeting is coming up to vote on the original deal, there clearly was a sense that there's no way that's going to get approved. I don't know if anyone actually came out and said that. They might have, but that has to be what was in people's mind, or at least a concern about whether it would get approved. You know, ARB's moving into the stock, and the question is, how do you do, I'll wave the letter again, how do you do this deal, the greatest deal ever imaginable, when there's some real doubt that the stockholders of Time are going to approve it? And the solution was this recasting of the deal to make it an acquisition for cash by Time of Warner stock.
And so it becomes a cash deal. This time it's going to be an outright, effectively a purchase of Warner by Time, financed, taking on a significant amount of debt.
Correct.
A week later, Dave's client comes back with a revised offer going after the new deal, and it makes a $200 per share offer. And then kind of all hell breaks loose, I think. I think it's fair to say the litigation goes into high gear. I'm going to skip that one for a minute. And from around June, mid-June through mid-July, you roughly have, there's a little timeline of some of the litigation in our slides, but roughly you have about 30 days to litigate what becomes the ultimate case. Maybe you guys can take us through a little bit about what had happened at the end of June, I guess, is when Lewis's client got involved. And what did you guys do, Lewis, initially in your litigation efforts, and what were you trying to accomplish?
Well, we were trying to have the shareholders be able to choose the Paramount offer and have that be something that could go to us and not be deprived, as we said in our papers, of the opportunity for a control premium for the foreseeable future. So that's what we were trying to do.
And I guess I should have said, and they said it before, but when the deal got recast, effectively the stockholder vote requirement under the New York Stock Exchange rules was gone, and now the cash acquisition was not going to require a vote of the Time stockholders.
Although there was still going to be an annual meeting
Right.
to elect directors, and I believe that as originally scheduled, well, it got put back a week from its original schedule because I think people must have felt that that recasting of the deal was such a material development that if there's going to be a vote on the election of directors, you're better off having that information to filter through the market first.
What was, Larry, what was the state of the record, and Ken, on the Time Warner side about the reasons why the deal was recast? I mean, did you own up to the notion that you were changing the deal in order to avoid the stockholder vote? I mean, did you just own that and deal with it, or did you try to sort of soft shoe around that to say, well, we had other reasons, business reasons, why we're doing the deal differently?
I think the record was that we needed to do this to get the transaction done in the face of the offer. And I think the fact that there would not be a shareholder vote anymore was a very central point, which we can all discuss in the litigation. But I don't think there was any question about the fact that this deal was changed so this plan, this combination that I described earlier, could get done. The shareholder vote presumably was part of that, but, we were up against the market reality of a cash offer, which on its face had plausibility, albeit conditional, and a need to take steps to preserve a transaction that the Time Board felt was the better business plan for it. The shareholder vote aspect of it was a great focus of the papers, the litigation, the argument. And we could all talk about, what our respective views were on it, but I was going over the briefs, and one argument we made that I thought was extremely compelling was that it can't be the law of Delaware that once you announce a stock-for-stock merger with a shareholder vote, and then somebody makes a cash offer for one of the participants, it can't be the law that you are then neutered, that you can't react, that you must go forward with a plan that has that same vote in it, instead of a different kind of plan to get this transaction in a non-Revlon situation through. And I thought that was extremely compelling. And it led into another argument we made that, and so you have to look at this revised offer as unto itself, and doctrine of independent legal significance. There was no vote required, and therefore it could proceed. But this notion that, you can't become a sitting duck, unable to move and respond, I thought was an extremely forceful argument that we made. I hope I thought of it at the time.
And Bill, I think we certainly would not have phrased it as we're doing this in order to avoid the stockholder vote. It was to make sure that this desirable transaction occurred. And sure, that was the
I
effect.
just said it with my plaintiff's hat on, but
Yeah. There was another fact that I had forgotten that was referenced in the Supreme Court's opinion, that Time and Warner went to the New York Stock Exchange to try to get the stock exchange to waive the vote so that they could consummate the original stock-for-stock transaction without a Time shareholder vote, and the stock exchange turned them down. And then
Never hurts to ask.
Yeah, it never hurts to ask. But that would have, I guess, preserved the debt-free nature and the accounting and the adverse accounting treatment that the recast
Avoided
deal-
the adverse accounting
Yeah.
treatment, yeah.
it's interesting. One of the things that struck me in looking at this, and Ken, I don't know if you remember back at that time, was there litigation from stockholders on the Warner side? Because clearly, I may say clearly, maybe it's as clear as mud, but if from the Warner side of things, you had a stock-for-stock merger, you wouldn't be subject to Revlon, and your stockholders, but maybe wouldn't have much of a claim. But when the transaction changes on your side of the equation, you're getting acquired, and at that point,
Since you're getting acquired,
Yeah.
QED, there's going to be stockholder
Yeah.
litigation, right? I don't recall.
Yeah.
It wasn't, if it did exist, it wasn't a factor. I don't see any reference to it in the opinions that I read or the briefs that I read, so I can't tell you for sure.
it's interesting. So, Dave,
Yeah, well, when Klein made his rebuttal argument, he represented to the court that Warner shareholders had not filed any suits. That it was that the revised deal was so good for Warner that there were no suits at all.
that's interesting.
Michael Klein was counsel for my client, the intervener.
And the premium, I had forgotten the premium numbers, but I guess in the original deal, the stock exchange was about an 11% premium for Warner, and then in the recast deal, it went up to 30 or 40% premium for the Warner stockholders, maybe more. I made a note of it, but so that was another change that happened. The deal got even better for the Warner stockholders.
Dave and Lewis, do you want to just briefly give us again, I think they're summarized in our slides a little bit, but in terms of what the claims were that you guys were focused on and what you were pursuing in the litigation, a big picture, the arguments you were making?
I actually thought our best argument was the recasting of the deal so no shareholder vote was required. And not so much because maybe that was a slam dunk argument, but because I was concerned our other arguments weren't perhaps as appealing. So we made it in two ways. One, we argued that it was a Blasius violation. The other was we argued that it was a Unical violation, which is the conception I like better, because I thought, and still to a certain extent think, that we had two good Unical arguments, that the recasting of the deal had taken this transaction from one that was non-coercive and the time shareholders would have a choice as to whether they wanted this transaction with Warner or the Paramount transaction, to a coercive transaction where the time stockholders were being forced to accept the combination with Warner instead of the Paramount, so that we had what I viewed as a coercive component under Unical. And secondly, and this is the argument we lost, that our CEO gave away in testimony, that the Times tender offer for Warner precluded the Paramount offer. So, and because the chancellor held that the recast merger was a defensive reaction to be judged under Unical, and I thought we had two pretty good arguments that it was coercive and preclusive. We lost the preclusive one when our CEO testified that it wasn't preclusive, that Paramount could still acquire the combined company, which I don't know. Anyway.
So going to Ken's point that this case brought to the court's attention a lot of issues that were unsettled in light of the fairly recent decision of Unical and Revlon and some of the cases before then. Our main argument, we did not give much hope to the Revlon argument. We had our argument that I mentioned before, that the original transaction put the company in play deliberately to make it so big that there would never be a control premium. So in effect, they were blocking the stockholders from ever getting a control premium for the foreseeable future. But the most important argument that we made was a Unical process argument. And what we said was, and I'm reading from what we said to the Supreme Court, that they just didn't examine alternatives after the Paramount offer came along. And here's some of the things we said the Time Board could have done but didn't do. They could have just said no to Paramount's opening bid, explained the benefits of the Warner transaction, the risks of the Paramount offer to Time stockholders, and proceeded with the June annual meeting and vote on the original merger. They could have just said no to Paramount's opening bid, postponed the June meeting to provide additional time to communicate with Time stockholders, and then proceeded with the annual meeting and vote on the original merger transaction. They could have explored the possibility of achieving their strategic objectives without coercing Time shareholders or depriving them of any current value by having Warner acquire Time at an attractive, fair price. They could have opened talks with Paramount to determine whether, despite the benefits and synergy of the Warner combination, Paramount would be willing to buy Time at a price that would exceed not only the short-term but the projected long-term values of remaining independent, or combining with Warner and maintain Time culture by having the same succession arrangements. And they could have directed the independent financial advisors to assess and perhaps pursue other financial or structural alternatives to the values offered by Paramount's bid. So our main argument was that they really didn't do their job under Unical to make a proper assessment of the threat posed or what the response ought to be.
And why don't we talk about, we've already touched on it a little bit, but let's really turn to the court's analysis of the issues. On the Revlon claim, and happy to have any one of you take this on, the chancellor had sort of made he says this is the heart of the matter. The board chose less current value in the hope, assuming that good faith existed and the record contains no evidence to support the supposition that it does not, that greater value would make that implicit sacrifice beneficial in the future. So the long-term versus the short-term value played a big role in the chancellor's mind. But the Supreme Court seemed to go a different direction. And maybe we can talk a little bit about that, because it's interesting, because in the clip that we saw from the Supreme Court argument, I thought one of the questions that Justice Horsey posed, and I thought it was a very loaded question, seemed to put a lot of emphasis on this, on the distinction between long-term and short-term value in the board's judgment in maybe trading off short-term value for the future. But that's not the way it came out in the Supreme Court opinion, and maybe have you guys comment a little bit on that. And maybe Justice Holland, you could give us a little bit of insight on that point.
I'll comment in the form of a question to Justice Holland. You can take it too, because I think there were other aspects of the Supreme Court opinion where the court, I thought, appropriately acknowledged the propriety of attention to the long term. I mean, wasn't as if the court, throughout its opinion, said just we're not going to talk about long-term versus short-term. So I'm curious about the back and forth that must have gone on in crafting that.
Well, I think, there was a lot of back and forth, and I think on this particular point, and we know today, and we kind of knew then, and that you got yourself into your Revlon duties three ways. You could decide to sell the company, you could have a change of control, or the company could be put in play and a breakup would be inevitable. And so the first decision we had to make was whether Revlon duties had been activated here. And I mentioned to you, we decided they hadn't been activated because there was no change of control. But then the opinion says, but that's not why we're going to decide the case. We're going to say Revlon didn't apply because a breakup wasn't inevitable. So the question about long run and short run really gets into the UNICAL obligations you have and whether you can consider the long run and the short run when you're discharging your UNICAL responsibilities. And that's something that had been left open after UNICAL, and that's something that the court had to come to grips with. But you could see that in Justice Horsey's question, is it all right for the board in defending to consider the long run? And one of the arguments that you heard and was briefed is that if the stockholders were patient and they went along with the Time Warner combination, in the long run, they'd be better off than taking all of this money that Paramount's offering today. And Lewis's clients, through Michael Klein, argued, anybody that wants to stay for the long run, God bless them. We want the money now. And so that was really the debate. But to the specific question, the long run, short run was addressed by the court in the dynamic of UNICAL.
We talked about the long-term versus short-term issue and the Revlon claim. The court, Chancellor Allen, and this is sort of, I think, one of the iconic, lines from Chancellor Allen's opinion. He concluded that the original merger agreement, because it was stock-for-stock transaction, did not trigger Revlon, and this is the line that you see repeated often in many of the later takeover cases relating to stock-for-stock deals, is that Revlon doesn't apply because before the merger agreement was signed, control of the corporation existed in a fluid aggregation of unaffiliated shareholders representing a voting majority. In other words, in the market. That is a very oft-quoted line. The Supreme Court agreed with it, and I think, as Justice Holland pointed out to me, it said in the opinion that his conclusion was correct as a matter of law, but nonetheless that the court went a different direction and found that there was not enough evidence, that Revlon was inapplicable on other grounds. There was not enough evidence to find that Times Board had made the dissolution or breakup of the company inevitable. And that the adoption of the structural safety devices alone didn't trigger Revlon. Those were subject to UNICAL. And I think that's where I really wanted to spend a little bit of time, was just on the application of UNICAL to the revised, or to the original transaction, and then to the revised transaction. Again, and after this next slide, I swear I'll stop talking and let Justice Holland maybe talk a little bit about the Supreme Court's decision. So as applied to the original merger agreement, the Supreme Court affirmed Chancellor Allen's holding that the time decision to expand the business of the company through the March 3rd merger was entitled to the protection of the business judgment rule. As to the revised deal, Your Honor, maybe you could talk to us a little bit about the court's analysis with respect to the UNICAL claim as to the revised deal. The Chancery Court had determined that it passed muster under UNICAL. Maybe you can talk to us a little bit about how the Supreme Court viewed this argument and where it came out on the issue, Your Honor.
You want to do that as a standalone issue?
Yeah.
And I think early on in the opinion, what we say is that we think this is going to be analyzed under UNICAL. And in UNICAL, you first have to identify a threat, and then the response to the threat has to be proportionate. And at the time, UNITRIN had not been decided, so what UNICAL said was it could not be draconian. So we've talked a lot about the threat to the time culture as a threat, but when you're trying to do proportionality analysis, this was a fairly significant defense. And as time, in the chronological sense, has moved on, big threats deserve a big response and small threats a small response. So in the opinion, we went out of our way to not only identify the threat, which was to the time culture, but we also talked about the timing. We talked about the fact that it was conditional, and you can look at the opinion. We really put down 4 or 5 things to identify the threat. And then after we identified the threat, we concluded that the response was proportionate. Now, one of the cases that's been mentioned a couple of times is Blasius. Blasius was decided by the Court of Chancery initially, and it said there are certain defenses that are permitted under UNICAL, but if the primary purpose of the defense is to thwart a shareholder vote, you need a compelling justification. So one of the things we concluded in talking among ourselves was the primary purpose was not to frustrate the shareholder vote. The primary purpose was to keep the Time Warner deal together. And, there were a lot of debates about how we were going to address that in the opinion. But suffice it to say, once we concluded that the primary purpose was not to frustrate the shareholder vote, and that kind of dictated where we were going with the rest of the UNICAL analysis.
So the slide behind us, or that's up there now, was a quote from the Supreme Court decision. Talks about the factors that a board can take in to consideration. And one of them, again, it's one of these ones we have debates on, I think, quite often, but the impact of, I think it's on constituencies other than shareholders. How far can a board go in considering other constituencies in this realm, in defending either a business strategy or some transaction, in terms of, can it take into consideration the fact that it wants to take into consideration its employees, its that type of thing? I mean, how far can you go with it?
Well, I think,
and I'll open that to everybody because I'm interested in people's views on this.
Well, I think, after UNICAL and Revlon were decided, when I teach this and other people talk about it, you basically draw a line down the center of the board, and you're either on the UNICAL side of the line or you're on the Revlon side of the line. And if you're on the Revlon side of the line, you have to consider shareholders, and that's it. And we talked about, in a lot of cases, including Paramount and QVC. But what UNICAL said is what's on the board here, and that is that you can consider other constituencies. And that's still playing out today. So you have fiduciary duties to the stockholders and the corporation. But if you're on the UNICAL side of the line, you can consider other constituencies. And your question is, how far can you go? And I don't think there's a test on how far you can go, but it's a proper consideration that that's consistent with your fiduciary duties. So I think that, if we look at considering other constituencies and make an analogy to philanthropy, when you're giving things away, and shareholders could say, well, you're giving away our money. And the board of directors can say, in the long run, it's going to be better for the corporation to have a well-respected brand, and we're going to make more money. When you think about other constituencies, you think about employees or other stakeholders, And you can talk about paying people more money and saying a happy workforce is going to be better for the company in the long run, so we should pay them much more than the minimum wage. So you have to make a connection, and it's going to be fact-driven. But I think we clearly wanted to reiterate here that if you're on the Unocal side of the line, there's a lot that you can take into consideration.
And this is this gets us back to the corporate culture business again, because the other constituency, as far as I was concerned, that was relevant here was the public and its interest in accurate information, accurate journalism. How far can you ride that horse? Again, I particularly felt it was necessary to do what Justice Holland just did, which was to say there is a link between that and value to stockholders. But, it's kind of hard to measure.
Now, Unocal lets you put a lot of things in the mix, and I don't think anything's going to be determinative, but you never know what's going to resonate with the court, so the more you can put in the mix, the better.
Dave or Lewis, do you have anything more you want to put in on that one?
Just that language in Unocal that we focused on at 4 o'clock in the morning was problematic.
I wanted to ask, Larry made this point earlier, and I was wondering whether Justice Holland had a reaction to it. The Chancellor, in his decision, drew a distinction between a defense that was the effectuation of actually a business plan that the board clearly had authority to do. In other words, making the acquisition of another company times acquisition of Warner was clearly within the power of the board to do, as opposed to a rights plan, the implicit, which he described as the self-created device to give the board a role where, at least before 203, and 203 was in existence at this time, but at least before 203, the board didn't have a role in. Is there a difference under Unocal when you're dealing with a defense that's a business transaction that has its own independent purposes versus a defense that is just purely for the purpose of defense?
Well, I think the purpose of a rights plan is primarily to defend against what's a threat, and at least at this point in time, threats were mostly inadequate offers, trying to get the price up. Here, and so normally when a board's articulating the threat, it would focus on the adequacy of the offer, but it would also focus on its culture and its long-term plan. So again, you have to put it in the mix, and I think that's really fact-driven, and that was certainly the case here.
So the Supreme Court ultimately determines that the deal gets upheld under Unocal, withstands the Unocal analysis. The oral argument in the appeal happens on July 24th, I believe, in 1989. You have the argument in the morning. We saw some clips from it. What happened? Like, maybe you can give us some insight, Your Honor, into what did the court do? How did it go about deciding the issues? And maybe you can lay a little background for the people in the audience about how it is the Supreme Court, at least at that point in time, went about deciding issues before the court.
Yeah, I think it's good to start with the background. And when I think of background, I always think of my grandmother, who was 89. And, once we found out this was going to be broadcast live across the country, I called her up and said, if you want to see what I do, tune in tomorrow. So she was in a retirement home. And I think after 5 minutes, she was kind of given the choice between Wheel of Fortune and oral argument and staying in the retirement home. So, they only got to watch 5 minutes of the 2 hours. But seriously, the way the court worked at the time, we assigned cases to panels, and so who the 3 justices were on the panel. And this was decided by the Court of Chancery on July 14th, and it was decided by the Supreme Court 10 days later. So the case was briefed and argued in the Delaware Supreme Court in 10 days. And someone's mentioned this, but it's a fact. There was no email. And as a result, we were dealing with paper. And the record in this case was 7,500 pages. Now, the appendix wasn't that long, but I was in Georgetown, and the record and the briefs were flown to me by helicopter from New York to Georgetown, just so we could keep things moving along. And our custom at the time was that the three justices were not allowed to talk to each other about a case before it was argued, and their chambers couldn't talk between chambers about a case. So the three of us went into that argument, like all arguments, having no idea whether we were going to be able to agree. But we knew that it was very important for us to try to decide the case that day for a lot of reasons. And like in most cases, these three companies were all incorporated in Delaware, and the New York Stock Exchange had suspended trading in all of the companies during the course of the day throughout the oral argument. And the parties had requested us to give them a decision promptly. After we heard the argument, we conferred at the bench, and we said, let's have everyone come back at 2 o'clock. And we had everyone come back at 2 o'clock, and we had conferred among ourselves, and what we decided was that we were going to affirm the Court of Chancery, and that we had to write a decision of our own. We simply couldn't affirm on the basis of what the Court of Chancery did for a lot of reasons, but that we needed to announce a decision. So we came back at 2 o'clock and we announced the decision. And then on a panel, you're allowed to issue the mandate immediately. So since we agreed, the case wasn't going to go en banc. And the idea always was if you have 3 votes, 3 out of 5 is a majority of the court, and you could issue the mandate immediately. So we issued the mandate immediately. So there we were on July 24th, having decided the case. And then the question was going to be, what was the rationale going to be for our decision? And we still had a self-imposed rule then of deciding things in 90 days, but as you know, it took almost 7 months to get this decision out. And that's because under our custom then and now, someone assigns the case and then becomes the primary architect. Here, Justice Horsey was the senior justice, and he assigned it to himself, which meant he was the primary architect of the opinion. But the opinion couldn't be released unless all 3 of us signed off in writing if it was going to be a unanimous decision. Now, we had all voted to affirm, but we thought it was important to have one opinion, not to have 3 seriatim opinions or 2 people and someone concurring. So we were going back and forth for 7 months, and there was really a lot to do. Now, we talked about one thing was, is this going to be Revlon or Unical? And you've heard a little bit about our deliberative process on that. And then we had to decide what were the defenses, were they proportionate? And then we had to decide if it was not going to be Revlon, why? And we talked about why we decided that. And clearly, someone wanted to decide it based on no breakup was inevitable rather than simply a change of control. And the question was, why wasn't Blasius important? And we had to think that through. And then we had other questions about collusion, being preclusive or coercive, and we had to decide how we were going to deal with that. And then you see at the end of the opinion, there's a statement to the effect there was a fundamental misunderstanding about where power lies in the corporate structure. And here, this was a decision directors could make, and if you didn't like the director's decision, you could vote them out of office, which is something that we had said earlier in Unical. So there was really a lot of back and forth on the court on maybe 5 or 6 legal issues that played out in subsequent cases. And we're going to talk about the legacy of Time Warner. But we had Paramount and QVC 4 years later, where we had to talk about control and why when Viacom and Paramount signed the deal on day one with control going to Summer Redstone, they had agreed to a Revlon transaction on day one. And later on in M&M and Liquid Audio, we talked about if the primary purpose is to defeat a shareholder vote, you have to show a compelling justification reiterating what we had said in Blasius. And then Unitrin was written 10 years after Unical, and it said, you know, one thing we've learned is that draconian means preclusive or coercive. And we cited back to the Time Warner case talking about things that would be preclusive or coercive. So to get the three of us to agree on all of these points and other points was really something. And I mentioned we didn't have email, we had faxes. And I had the same secretary for 37 years. But during this time, she one time came into me and said, I think the fax machine's going to burn up. And it wasn't because it was a long fax. It was because there were a lot of strong feelings on a lot of points on a regular basis. So it was an interesting process. But at the end of the day, we all agreed. And, you know, another example, we talked about the Interco case, Interco and Pillsbury. Those two cases, like a lot of cases, were decided by the Court of Chancery, but never appealed to the Delaware Supreme Court. And I was saying to Lewis, you know, one of the things you always have to think about when you're writing an opinion is, should there be dicta? And is dicta helpful? And generally speaking, we avoid saying things like, and by the way. And so that was a debate in the Time Warner decision, how many by the ways we were going to have, either in the substance of the opinion or the footnotes. So it was a really interesting process.
We were gonna put you on the spot about that Interco, the reference to Interco in the opinion, but you already touched on it. So how was it? I'm just curious. So this Supreme Court argument gets televised. How did that even come about back then? Like, had anything ever been televised prior to that time in the Supreme Court or in the Chancery Court, for that matter, at that point?
Yes. In 1982, 7 years before this, Chief Justice Herman had entered an order that said Delaware Supreme Court cases could be televised. No trial courts, but the Delaware Supreme Court. And in my time on the court, there were only 3 cases televised. One was a capital murder death penalty case. One was this case, and one was Paramount and QVC. But generally, even though we had that order in place since 1982, everyone was like my grandmother's rest home. Nobody was interested. But Time Warner was this big media case. And because of that, they came in and invoked the 1982 rule and said, we want to televise this case. And under the rules, anybody could televise it. You just had to give the feed to everyone. But they decided to televise it for the whole 2 hours. Now, one thing interesting I mentioned in this case, trading in the shares was suspended, and because that was the norm and nobody really knew until the last minute this was going to be televised. That's why Lewis and other people were getting these free tickets like a lottery. But when we did the QVC case 4 years later, everyone knew it was going to be televised in advance. So the New York Stock Exchange did not suspend trading. So I have a copy of the Wall Street Journal from the day after the oral argument, where they tracked how the stock traded during the 2 hours of the oral argument. And there's one part on the graph where there's a downward spike with a note, Paramount lawyer was grilled by the justices. So, but those are the only 3 cases that were ever televised. Now, in the current conditions with the internet, the Delaware Supreme Court arguments are on the internet every week. So, if you want to watch it, you can all the time. But back then, just as there was no email, there was no internet television. And still to this day, the internet broadcast is limited to the Delaware Supreme Court. And you're not able to get, taping for internet purposes in the trial courts.
And before I get Louis to talk about this document that's up there behind us, he's a pack rat. He kept his ticket from the Supreme Court argument. But Your Honor, the appeal that came up to the Supreme Court from Chancellor Allen's opinion was not an appeal as of right. It was an interlocutory appeal. And, nowadays I think I would say the feeling is the Supreme Court has gotten a little tighter on, and the Chancery Court has gotten a little bit tighter on in terms of approving interlocutory appeals. Was there ever any doubt here, and I'll ask the panelists that the Supreme Court was going to hear this interlocutory appeal?
Well, the way that works, and I think it still works today, is that the request for an interlocutory appeal is really a motion. And the motion goes to a motion justice, but there are two other justices assigned to that justice's motion panel. And the motion would be considered by all three justices. So in this case, the three of us decided to take the interlocutory appeal. And we took it for a lot of reasons, not the least of which was the fast pace of the takeover litigation throughout the Court of Chancery. And things were moving so quickly that frequently when you got a decision from the Court of Chancery, there was not going to be an appeal. So we realized that there were important legal issues in this case, and if we were going to weigh in on the issues, we had to accept the interlocutory appeal.
Did the defendants oppose that?
No.
I think it was a foregone conclusion.
Yeah, so the three of us decided to take it, and then we decided, that it had to be expedited for the reasons I mentioned. And that's still the way it works. If there's a motion for an interlocutory appeal, the motion panel, all three decide yes or no.
All right, now, Louis, you got to tell us, where did you dig this ticket up from?
I remembered that I had this ticket, and I didn't know where it was. So when I was asked to serve on this panel, I said, I wonder if I could have a visual aid that I could contribute to our panel. And I was able to find this. At the bottom, you see the initials of Steve Taylor, showing the stamp SDT. And the argument was held in, I think it was courtroom 8, which was a Superior Court. It was the largest courtroom in the old Herman building. But obviously the lawyers had to be able to attend, and there were a lot of lawyers from a lot of different firms. So this, I guess, was a special lawyer pass holder. And so they gave these tickets out to the lawyers who were counsel in the case, and after, I presume that the lawyers told the court how many lawyers from each firm needed tickets. They got passes, and then after that, they could issue tickets to the public based on the available seating.
And now I should say that my wife and son had seats in the jury box. They didn't need to get a ticket.
So, but before I want to talk the last part of this about sort of the lasting impacts of this decision and how it's still relevant today. But before we get to that, I want to throw out to the panelists, in particular the litigators, what were the most memorable moments, or any kind of aha moments or funny moments from the litigation that have stuck with you for the last 30 years, and maybe even you can give us a little bit of insight in, were there mistakes that you made, the things that you would do differently with the benefit of hindsight? I don't mean to stump anyone on that one, but I'm just curious. Anyone want to go first?
I can start because I've already told it. That the story about my encounter with Dave was kind of entertaining, but it was also revelatory to me and guided and influenced me significantly in how I thought the case needed to be presented, because the time culture was never quite the talisman after that I thought it was going into the case. The only other thing I remember vividly, aside from the fireworks over from Cravath's offices, was in doing the brief, our brief in the Supreme Court. It was an all-nighter. I remember that vividly also. And this was in our offices in Wilmington. And for reasons that I've never understood, Times investment bankers sent a representative down to work on the brief with us. And fortunately, I don't remember his name. I don't think he was anybody who was described in the opinions, so it's pretty safe to refer to him. But it was the most aggravating night I've ever spent working on a brief. It was, why are you telling me how to write a brief? That's not what's going to fly in the Supreme Court. And so it was, you talk about your facts burning up, Justice Holland. This was me burning up while I'm trying to get this brief out overnight.
I've got a story that involves Judge Jordan when she was an associate. I was taking Jerry Levin's deposition, and we, after being filibustered for a day, we went to the chancellor and asked if we could have another day of deposition. He granted it. And that evening, I think either late afternoon or evening, we got a whole new document production from the defendants. And I'll refer to as Jan because it's only the context. I called Jan and I said, we just got some new documents in, and could you guys go through these documents? And I said, one of the patterns is that if there's a good document for us, it often ends up being in the last production buried in a bunch of junk. So pay some attention to this. There might be something there. So I went to sleep, went to bed, and at about 3:30 in the morning, the phone in my hotel room rings. I get up, I go over, I answer the phone, and it's Jan. She says, we've been going through these documents, and I think we found something. I go, really? She goes, yeah, I'm not sure, but I think this is pretty good. So she told me about this document, and then I got dressed and went to the office and to see the document. I thought it was pretty good, too. I guess I never was very effective at getting anybody else to think it was. It was a document with handwritten notes. I forget who the author was, of notes taken from the Times side in advance of a negotiation with Warner with respect to the first merger. And it had, my recollection is, I've been trying to find this document ever since I first talked about this case in one of Larry's classes. My recollection is it had 6 bullet points. And the first bullet point was management contracts. And the 6th bullet point was the exchange ratio. And written, I think, in the same place that near that 6th bullet point was a notation, we'll trade 6 for 1. In other words, we'll give Warner a better exchange ratio if we get the corporate culture, time culture embodied in these employment contracts. Well, I thought this was a dynamite document because I thought, my God, this is the management of the company for a self-interested reason trading shareholder value for their own employment agreements. And so I took it into the deposition the next day, and I gave it to Levin, and I asked him, do you recognize this document? And he said, yes. And this is my recollection of how it went. And I asked him, what is this? And he explained what it was. And then I asked him to confirm that I wasn't misunderstanding that that what this document says will trade exchange ratio for employment agreements. And he confirmed that's what the document said. And he looks at me and he goes, I can explain this. And I stopped and I'm going, do I want him to explain this or do I not want him to explain this? So I said, never mind. And I went on. But I guess the explanation would have been time culture.
So first of all, Dave, I'm sorry you didn't share that document with me because I would have had it today to share with you, but
Yeah, if you kept your ticket, you surely would have kept it.
you didn't give that to me. Again, the only clear recollection that I have is that time period, every single day, late into the night, every day, between whenever we got into the case, which must have been the first week of June, until July 24th, it was nonstop. And again, we didn't have the benefit of email, so we were getting these deposition transcripts either somebody drove them to our office or they overnighted them. So there might have been a slight delay, and we were writing the brief as the depositions were coming in, and we kept having to change the facts as the depositions were coming in, and that was a continuous process. The one aha moment I do remember is that at some point in the briefing, I think at the now Wilmer Hale offices in Washington, again an all-nighter, when we were dealing with the time culture argument, and then we got to that language in Unical about considering other constituencies. We didn't really have an answer for that. We had gone through their brief. We were just double checking that we'd answered everything, and we said, in language not quite like this, but what do we do about that argument? And we didn't really have a good response in light of those points in Unical. So I do remember that at 4 o'clock in the morning.
Ken, anything?
I don't have any great war stories. I've been trying to think of one since I heard about this panel. And other than trying to get on camera at the oral argument, I don't really. But I do remember that I always thought we had the upper hand in the case, Time and Warner. And one of the reasons was, and this I don't think it's really emphasized yet today, Unical allows you to be responsive. If there's a perceived threat, a board can be responsive. In this case, however, the plan, the response, was in existence for months before Paramount came in. And I thought that gave us tremendous credibility in advancing this business plan. This was not some knee-jerk response, although, many responses are well considered, even though they're not pre-existing. But in this case, the fact that it was in existence for all those months, the fact that it obviously had merit, whether one thought one was preferable or the other. I always thought that Delaware would want to uphold it. And, years later, one of the cases I was involved in, I think it's 2011, was air gas. And it was a case involving rights plan. And again, there was no merger, but we relied on a pre-existing business plan. And again, for a company that had been very successful. And again, it had a lot of credibility. It was real. And I thought that, and it cited Time Warner ultimately a number of times. So that was my overall, I was confident throughout that matter. I was tired. I was, it was a busy period, but I always thought that this was one where we had the better of the argument.
So, at the time the Paramount v. Time case got decided, obviously it was an important decision. Did the decision, in anyone's view, have any impact on sort of hostile takeovers at the time? And, did it put a damper on bidders coming forward with hostile bids? Did you feel any impact of it at the time? And I guess measuring it, looking back now 30 years, did it have any impact? And what is the lasting impact of the decision, I guess? That's a somewhat loaded question, but.
Yeah, was there any? And it's something that Justice Holland touched on briefly that I actually wanted to come back to him about, and that is the dictum about Interco and Pillsbury. Because the way I remember people reading that dictum after the Supreme Court opinion came out was, Interco and Pillsbury got overruled. But if you read the words carefully, it didn't say that. It was to the extent that those opinions require the court, permit the court of chancery to engage in, essentially, I'm paraphrasing, but second guessing or substituting its own judgment about the business merits of a bid, that we reject that. So I'm curious, Justice Solomon, if you can say anything about it, but whether I'm being too hard on people who think that that was a matter of overruling those cases.
Yeah, I don't think that was the court's intention. And as you can gather from what I've said, every paragraph in that opinion was really thought about carefully crafted. There was a lot of back and forth between the three of us. And to the extent those two cases were a subject, the first question is, what, if anything, do we need to say about them? And then when we say it, what do we say? And I think to the extent the court decided to make a comment, the plain language, I think, indicates it was making a comment without making a decision. And so that was really what the court was trying to do, was to make a comment. But it's interesting, Justice Traynor can relate to this. When opinions are circulated, the named author is the primary architect, but everybody has to sign off in writing. So one of the strengths of the Delaware Supreme Court is that the opinion is the opinion of the court. Everybody agrees. So if we look at this reference to Interco as an example, I remember once writing an opinion where someone wanted to put in a footnote, and to me it seemed fairly innocuous. Fine, I'll put in the footnote. So everybody agreed. We issued the opinion with the footnote. The next thing I know, people are writing law reviews about this footnote. And I'm saying to myself, well, that really wasn't my idea. So I'm not saying the Interco paragraph was not my idea, but we thought carefully about the way we wrote it.
Well, just looking at that footnote, it seems to me you actually said, to the extent that the Court of Chancery recently substitutes its judgment for what is a better deal, we reject such approach as not in keeping with a proper unical analysis. Then you said see Interco, which was a Chancellor Allen decision. But then you also say but see TW Services, which is also a Chancellor Allen decision, which to me was saying, okay, you got it right in TW Services. So see Interco, that's where we think you substituted your judgment.
There was a big difference between TW Services and Interco, because I was represented the bidder in TW Services, and we made a proposal, we made a tender offer that was conditioned on the board approving a merger agreement. And Chancellor Allen, I thought quite correctly, drew a distinction between the board's power with respect to merger agreements and the board's power with respect to responding to tender offers. Now, I don't know whether that juxtaposition of those two cases was to suggest that the board's power in responding to tender offers should be closer to what it is in responding to mergers. But I've got one little anecdote to tell you about the follow-on of this decision and then QVC. We were involved in QVC, and I got two significant calls in the course of that representation. The first was from Ted Vervis at Wachtell. Ted called me and said, we're going to be representing QVC and we're making a bid for Viacom, or Paramount. And I said, your firm is going to represent a hostile bidder? I don't think you guys before then had ever represented.
Not true. Not true.
No? All right.
Not true. It's rare, but it happened.
All right. I thought, wow. Then the other was from Mike Chapika, who I worked with on Time Warner. And Mike called and said, I see you guys we had filed suit by that point. He says, all I can say is I can't lose both sides of the same issue.
So I always thought that the Time Warner decision actually was the end of this era that we talked about. And I always thought that because it clarified a lot of things with respect to Unical and Revlon, that the decision on its merits affected things from a transactional perspective. I don't know if I'm not a transactional lawyer. I always understood that. Now that I reread it, I can see why that could have been the case, because number one, it prevented a disappointed competitor from launching a bid and then all of a sudden taking control from the board with respect to a transaction that it favored. So therefore, there were going to be less business reasons for a competitor to come in and try to disrupt a transaction. It also gave more encouragement to the board to develop long-term plans and have them in the kitty and in the minutes about our long-term plan and our long-term strategy, which therefore, assuming that people were well represented and had those minutes, it was going to be harder. You could just imagine somebody trying to disrupt that. So am I right about that, or were there other? Because certainly the boom ended after this decision. Whether it was caused by this decision or this decision played a role, I don't know.
There was a bank crisis too. The savings and loan crisis reached its. I think the most significant part of Time Warner is what it didn't do. Because imagine what the law would have been if the court had said, Revlon is triggered anytime you enter into a merger agreement, effectively. That would have made companies much more vulnerable to a hostile offer than they perhaps perceived that they were. Or if every time you did a defense against a hostile offer, you had to demonstrate that the long-term value of the course of action you were attempting to pursue was better than, on a cost of time adjusted basis, than the immediate value that were being offered. That would have, either of those decisions would have significantly expanded the leverage of the hostile bidder. So I think in ways it sort of, to me, Time Warner sort of reined in Revlon and Unical in a way that otherwise would have been notable if they had expanded.
And even though I still don't read the dictum about Interco and Pillsbury as overruling or saying that the court got it wrong in Interco, there's no question that it gave a lot of comfort at a time of uncertainty to people who would use the pill as a defensive mechanism. And in fact, it took maybe decades, maybe till Airgas, before there was maybe more Wallace, but challenges didn't happen nearly as frequently as I think they might have.
Well, look, I always give the last word to jurist or a former jurist in this case, and Justice Holland, what are your kind of, if you have closing views on the lasting impact of this decision and how it fits in the fabric? And I think that'll be maybe our last comment, and we'll let folks go to lunch.
Well, I think where it fits in the fabric is that was the first time the court really had to focus on the distinctions between Revlon and Unical in a variety of ways. And I think, as other people have said, it provided guidance for people. And as a result, there wasn't a lot of litigation. And the litigation we saw was much more focused. So I think the lasting impact was that it answered a lot of questions and provided some guidance for the future, and that later cases were more focused on single issues, whereas you can see in this case, they were really a focus on multiple issues. And the court was aware of that when we were deciding it, and that's why we took our time and we tried to be very deliberate about what we actually decided and what we commented on.
Great. Thank you. I think that's it.